All right, so do we want to call the meeting to order pretty soon here?
Yes, you can go ahead and call the meeting to order.
Okay. So in the absence of the president, I'm going to go ahead and take over here. So I'm going to call this meeting to order at 9:03, it looks like, from here. Bang. All right. So roll call will be the first thing we got on the agenda here. So could I have a roll call, starting with Jeanette?
Jeanette Melby, present.
Joanna Tran, present.
Neil Hoffman, present.
Alex Leader, board member, present.
Gary Landry, Executive Director, present.
Is
Sarah Bradley, Deputy Attorney General.
Koki there?
Yes, and you already got me.
Oh, I'm sorry, I didn't hear you. Perry Nixdorf, Vice President, present. Okay, then we got Gary, then Adam.
Adam Higginbotham, present.
Andrew Helms, Chief Financial Officer, present.
Mr. Green.
Gloria Alexander, Office Manager.
Annie Curtis, Chief Inspector, present.
Jeffrey Green, Chief Investigator, present.
Monica Bradford, Executive Assistant, present.
Perry is Charlene, present there.
Yeah.
Charlene Marsh, Inspector 2, present.
We also have one other person.
Rodney Moore, Inspector 1, present.
Thank you very much. Is that everyone now?
No, we have two others, Mr. President.
Please.
Diana Ball, Field Inspector 1, present.
Push this. It's already. Hi, Pamela Fitzgerald, Inspector 2, present.
All righty, is that everybody now? All right. So then that works for that. That's roll call. All right, next, Pledge of Allegiance. Would you please rise? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, and with liberty and justice for all. All right, thank you very much. All right, now we'll read the mission statement. The mission of the Nevada State Board of Cosmetology is to protect the public health, safety, and welfare through education and ensuring only qualified persons are granted licenses to perform cosmetology in the state of Nevada, and that all areas where cosmetology services are provided are kept clean, sanitary, and safe. Okay, onward to item number 4, comments by the general public. For those of you who are attending this board meeting for the first time, I would like to review the process we follow. To ensure the public has maximum input into the board proceedings, we will adhere to the following format for all agenda items that are not a part of the formal hearing or citation appeal. Number 1, the agenda item will be read. Number 2, comments from staff will be heard. Board members may question staff, and then members of the public who wish to give input will be heard. I will then close the public input portion of the agenda item, and the board may discuss the agenda item, at which time they may ask for clarification from the staff, the Attorney General's representative, or the general public. 4, after discussion is complete, I will ask for a motion, which, if made, will be discussed by the board. 5, after discussion on the motion, I will call for a vote. 6, after the vote, I will restate the motion of the status of the vote. Now is the time the board will entertain comments from the general public for any item that is not on the published agenda. Please limit your comments to 3 minutes or less. Would anyone from the general public wish to speak about an issue pertinent to the Nevada State Board of Cosmetology, but not on today's agenda now? No one's coming forward here. Anybody there?
Nobody's coming forward here, Perry.
All right. Then let's move on to item number 5, consideration and approval of the agenda and its posting. Was the agenda posted in accordance with procedures? Let's see here.
Yes, it was posted according to the meeting law, open meeting law requirements.
Thank you. Does any board member wish to propose a motion to accept the agenda or its posting? I would like to have a discussion about that real quick first. I would like to propose that item number 18 be placed after item number 20.
Done.
Okay. So then can I get a motion to accept the agenda as modified?
I make a motion to accept the agenda with the modification.
I'll second that motion.
All right. Motion passed. All right. Item number 6.
Perry.
Yes.
Perry, you need to call for a vote before approval.
Oh, that's
vote,
right.
yeah.
That's right. That's right. Sorry about that. Skipped that right over. All right. Can I get a vote?
Aye.
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 With all due respect, there should be discussion after a second if there's any other discussion regarding the motion on the table prior to asking for the vote.
Okay. Has everybody voted, or do we want to have a discussion on that?
I think what he's saying, Perry, there should be a discussion before you vote.
I understand. Since we just, most of us voted, or did we all vote just now?
Can I make a suggestion? It's kind of hard, Perry, with you up there and us down here. Maybe that we appoint somebody down here to do this so that we can be a little bit more uniform and not take so much time up with the audience with going back and forth like this. Would that be acceptable to you or to the board members?
Well, it's just a few more minutes before we get to the complaints. Let's give it a try for a little while longer, and we'll see how it goes here. All right. So, is there any discussion on the agenda item that I would like to move to number 21, 18 to 21?
Mr. President, is now the opportunity to pull the items from the consent agenda since you're making changes to the structure of the agenda for today?
Normally, this is just a routine item, and you're just talking about whether or not the agenda has been posted according to open meeting law. Historically, you have moved items as well if you know ahead of time that you'd like to, move in the order. You wouldn't talk about the consent agenda till you get to that item.
Okay.
So if you have things you want to pull from the consent agenda, you do that when you get there.
Okay.
So the change, because you can't really make complete changes to the agenda anyway. The changes are just to move the order of items or defer something to another meeting if you know that you need to do that at this time.
Thank you.
Okay, so any further discussion? All right, then I'll call for a vote. All in favor to have the agenda as is with the one modification, say aye.
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 Aye. Any nays? All right, motion passed. Agenda number 6. The board will consider approval of the minutes of the August 4th, 2014 board meeting. Is there any discussion by board members on the minutes?
I make a motion to approve.
I'll second that motion.
All right. Then I'll call for a vote on the motion to approve the minutes. All in favor, say aye. Aye.
Aye.
Aye.
Aye.
Any nays? All right, motion carries. Item number 7. At this time, I will adjourn the board meeting and call to order the public hearing on proposed temporary regulations. I adjourn the board meeting at 9:14. I call the public hearing for the proposed temporary regulations to order at 9:15. Okay, so the agenda item reads, public hearing on the proposed temporary regulation changes. The board will receive and hear all public comment regarding proposed temporary regulation changes concerning A, setting the fees at $100 for the first subsequent licensee violations to provisions of NAC 644.307 to 644.355, inclusive and not requiring an appearance at a board disciplinary hearing for said violations unless determined by the executive director. B, removal of the requirement to wear white garments and shoes for the practical exam. And C, reducing the fees for re-examination. Public comment may be made in person or submitted to the meeting in writing. The deadline for receipt of written comments is October 27, 2014 by 5 p.m. So, do we have any public comment? There's no public comment here. Do we have any there?
None here, Perry.
Okay. So that was number 8, was the board will consider fully all the public comment received regarding in the proposed temporary regulations heard under agenda item 7. There's no public comment. Number 9, adoption, amendment, or repeat, right?
Wait. Did we receive, just for the record, let's put on the record whether or not any written comments were received or other comments?
There were none received.
Okay, thank you.
No written comments or public or comments received from the last workshop. The workshop, we did actually have a few people speak in support of all 3 regulation changes, but nothing received since the workshop.
Thank you.
I just wanted to make sure the record was clear.
All right. Number 9, adoption, amendment, or repeal of proposed temporary regulations. The board will discuss and determine whether to adopt, amend, or repeal the proposed temporary regulations heard and considered in agenda items 7 and 8 as a regulation of the board for possible action. So, we are discussing whether to adopt, amend, repeal, or propose the temporary regulations. Does anybody have any discussion they would like
Perry, I have, just for clarification, adopt and amend, what would be the difference? Or do I want to add something to this? Is that what you're saying?
That is correct.
That's just the language in NRS 230-33B. So you're either adopting, amending, or repealing. And repealing just means getting rid of old sections. Amending is amending the existing code. And then adopting would be a new section, but that language is just straight from 233B. That's what's in your notices, and that's what was put on a previous agenda when we had a more detailed regulation. So it's just the agenda item.
Thank you, Sarah. I'd like to move to approve to amend.
What were you amending? Because what we have here is we have a document.
I'd like to amend. Okay, go ahead, Perry.
We have this document here that was provided to us that shows us exactly what it was that has been added, amended, stricken from the NAC 644-700.2. And so if you'd like to amend something to that, or are you okay with the changes as laid out for us here that they want to make?
I'm amending NAC 644.700.2 as prepared in this document that was given to everyone.
I think, would we be adopting that, right? Because you're not making any changes or adding anything to this.
No, I think we're amending, aren't we, Sarah?
Well, you'd be voting to adopt the changes as proposed by staff and as workshopped and noticed for today.
Right.
So I would just say you're voting to accept the draft that's been presented and adopt that as a regulation of the board.
Okay, I move to adopt the resolution that was made to NAC 644.700.2.
Mr. President, I'll second the motion to adopt the proposed changes to NAC 644-700.2.
Thank you, Mr. Leader. Ms. Booth. Any further discussion on this matter? All right, then I'll call for a vote. Let's see here. What does it say here? All right, so all in favor, say aye.
Aye.
Aye. Aye.
Any nays? No nays. Motion carries. Okay, so now I would assume that what we have to do is, since this was since the board received the, let's see here. Since we came out of a meeting and we entered into a new one, don't we have to close that meeting now? And then
well, no, we have two more sections in the regulation that still have to be approved. So the regulation that she made the motion on was NAC 644-700 sub 2. But if you look at the next page of the draft that you have, there's also an amendment to NAC 644.053 sub 8. And then there's also another amendment on the last page, number 3, to NAC 644.062 sub 7.
Mr. President, if it would please you, I'll make a motion to combine the adoption of both of those proposed changes.
That would please me.
If you'd like me to do that. So I would like to make a motion to adopt the proposed changes to NAC 644.03.8 and NAC 644.062.7 as presented by staff.
I'll second that.
And I accept the change.
Any further discussion? Having none, I'll call for a vote. All in favor, say aye.
Aye.
Aye. All, any nays? None, motion carries. Okay. So then that takes care of 7, 8, and 9, does it not? And so then
we could go to number 10. The Deputy Attorney General that's supposed to be joining us, I told her we didn't need her till 9:30. So if you'd like to do number 10, I'm thinking we can do that. And then if we have a few minutes, maybe move on to some other board business before 9:30 when Ms. Reynolds will arrive.
We close this portion.
yeah, we have to close this portion of the meeting, do we not? I mean, I got to go back here to my notes here.
Yeah, you can just say
Okay.
that you close the public hearing because you've adopted the regulation, and then we would reconvene the meeting.
Okay, so I'm adjourning the public hearing for the proposed temporary regulations at 9:17, and I will open the board meeting again at 9:17. So now we're back into our board meeting. Okay, that puts us at item number 10. Appearance by Tanya Hill, Associate Warden, Nevada Department of Corrections, speaking in support of a proposed cosmetology school within the Women's Correctional Facility. Is Tanya there?
She is.
Could she come forward, please, and have her give her proposal?
Good morning. My name is Tanya Hill. I'm the Associate Warden of Programs at Florence McClure Women's Correctional Center.
Good morning. All right. If you do you have a speech you would like to give us?
Actually, I do not, but what I would like to say, I do understand that there is a proposal on the table to consider expertise cosmetology partnering with NDOC to start a cosmetology program inside the women's prison. We do believe that this would be very beneficial as we're moving to help definitely our female offenders gain helpful vocational experience. This way they'll be able to come out with a trade where they could go and actually earn a sustainable living wage upon reentry into the community. And we would definitely appreciate the support of this board as we move forward in that venture and making that project a success.
Ms. Hill, do you have any obstacles that are in your way?
At the moment, I don't think there are any obstacles. We're looking at funding options and how we would configure the space and the getting the people involved and getting the school on board. But I wouldn't say any obstacles. I do believe we just need to finish working out the details.
So
Perry, I have some questions.
Go ahead, Koki.
Am I allowed to ask a question? I don't know.
Absolutely. Go
I have
for
a
it.
question. Question of expertise. Could they come forward? I just want to say, I think this is a wonderful idea. It's very exciting to me. I just wonder, will you be able to put a system into the prison and be able to meet all the criteria, or are you going to need some help with that? What is your thoughts?
Good morning, Gwen Bramo, Expertise Cosmetology. What we're looking at is because of the limited space that's inside the correctional center, we're looking at something in the regulation for space and not the same requirement for equipment. I believe it's space requirement and the equipment requirement.
So we'll need to approve variances for those?
Mm-hmm.
Sarah, is that something we can do a variance for?
Well, no, there's actually, it would require a change to the NRS, and I believe there's a bill that's supposed to go forward this session that will make those changes, or at least allow there to be deviation from those areas. So I think this really is just informational for you to know this is happening and for the board members to hopefully support it. And I believe those changes are already in the works.
Yeah,
Thank you.
Just to concur with Sarah's comments. In NRS, there are two requirements that may cause some difficulty for locating within the women's prison. One is the 5,000 square foot minimum space that's required. That's in NRS, so there would have to be a change in the law to allow that, to allow specifically prisons to have the variance on that. And then the other would be the minimum 25 students. Typically, those requirements are for making sure that a private school that's opening up is funded, has the right amount of students and all. It's a far different situation within the prison system. So those would be the two. And as Sarah said, my understanding, there's nothing definitive yet on as far as law changes yet, but there are things in the works to make those two small modifications.
I just like to say, I think that will be great taking to the legislative body, because I think that's a great thing to get these women with a profession when they come out of prison so that they can support their families and themselves. So I think that's a great tool to take forward to our legislative body. Thank you.
I just wanted to say, too, actually all across the country, we are trying to model our program after other states. So we have a list of states that I could bring before the board that actually have barbering schools, cosmetology schools in their prison system, so that when the participants are released, they can be released with some type of training or trade. So we're not quite sure how many participants. I know that we would be going through our state board on the minor offenses, and Tanya can kind of speak, because they're already now doing special programs at the Women's Correctional Center for training already.
That's correct. We are currently actually launching a new pilot reentry program, which will focus on vocational training, certified vocational training, employability skills, self-esteem, self-concept trainings, things like that, that'll help the women when they're released be able to, again, go out and earn a sustaining livable wage, and that will also help them successfully reenter into the community. If we're able to get the cosmetology school on board, that will just further those efforts and provide additional vocations that the women will be able to participate in. We can definitely work with the board. We can work with the school with regard to certain crimes that would be allowed to participate, certain demographics that would be allowed to participate, criminal history, sentence structures, things of that nature, which would have an impact on who should actually partake in the program at any given time or at a particular time in their sentence structure. We would want the program to run when the inmates are close to release, so that the skills are fresh, their excitement is anew, so that when they do get back into the community, they are invigorated to go immediately and get into work and find something that they can do that they will enjoy. We do currently have, I guess you could say, a small-scale beauty shop within the facility that we run so that the women have an opportunity to get their hair done and kind of keep themselves beautified. As we know, especially as women, we like to look nice and things like that. And just because they're inmates, that doesn't diminish their personage as women. And one of the things that we find working with women offenders is when you allow them the opportunity to still have some level of self-expression in terms of their femininity, it certainly helps in the management of the prison. It helps them feel like they have a say in what's going on in their lives. When you're incarcerated, you have very little say in what's going on in your life. So things like this will help to enhance that for the women. And again, and it gives them something to look forward to as our state is really moving in reentry areas and looking at how we deal with offenders or their reentry into community. These are the types of things that really help and really benefit the state of Nevada as we move forward.
So, Mr. Landry, this isn't something that we're pushing forward. Who's the one that is sponsoring this bill, and how are they? How are we tied into that? In other words, do we have to give you any express permission to help push this forward and lobby on our behalf or anything like that?
That would be beneficial. When bills get to the legislature, if they're two separate bills and they're from two different bill sponsors, but they're on the same topic, it's always good to know that we would work together to get things resolved. Sometimes the legislators may want to combine into one bill and have it presented as one. That it would be that the board is in favor of that, and that's why the discussion today, to make sure before legislature starts in February, that to get the board's sentiment whether there's support for this or not, and to give me guidance as to how I should work with our legislators going forward. I just want to mention one other thing. I've done a little bit of research on the cosmetology cosmetology schools in prison. Even though it's a new concept for us, it's not a new concept. Alabama has had a cosmetology school in their prison system since 1941, so it's been a long time. In there, 28 states have active schools already. 2 are considering it, so 30 of the 50 states will have cosmetology schools. Hopefully, 31 of the 50 states will have a school of cosmetology in the prison systems. And the unifying fact that permeates all of them is that they typically score higher than any school out there, any private school, public school, whatever school. The scores are typically higher, and the graduation rates are higher from the participants within the correctional facility.
My other question on that matter. Just one moment. My other question on that matter is the good moral character. How is this going to influence that? Because typically someone that's in prison, going to prison, or we tend to deem of not such good moral character. How are we going to handle that?
Currently, the board policy and the policy within our office, when I say board policy, board staff policy, is that if you are convicted of a violent crime, a violent felony, then you would not be allowed to test without coming before the board and getting special permission to do that. If it's misdemeanor crimes, if it's felonies but nonviolent, typically there's a review. I request a review of their rap sheet, their convictions, when they occurred, whether they've gone through rehabilitative training, all of those type things. And we have a number of active, participating cosmetologists, estheticians, and nail techs who do have some criminal past in their background, but those are all reviewed on a one-by-one basis when they apply. Just as Ms. Hill had indicated, they're going to go through a screening process at the prison, so they would screen out the violent offenders for the people going through the course. It's typically the rehabilitation programs are on a merit system, so those people who are the most trusted trustees are the ones that typically get into that. I have some experience with that in the Colorado prison systems, where my brother-in-law was a CFO for the prison system. So I've got some knowledge on how they do that in Colorado, and the merit system that you have to go through is pretty rigid. No one who's a troublemaker typically gets in any rehabilitation program.
Thank you. Any other discussion from any other board members now?
I just wanted to say, Perry, I have always been an advocate of boutique schools and this sort of thing, because I think the more people that you can get educated in an area that can give them further growth and encourage their job skills and enhance those job skills. So anybody that knows me knows this has always been a favorite subject of mine, is a boutique school and not making it so hard so that we can do something like this. Because to me, this is what we need to do for those young women. Maybe they've done something wrong, but we've all done stuff wrong, and maybe we just didn't get caught. So I just think it's important that we really go down this direction, and I appreciate the comment. Bye.
Mr. President, I have a couple of comments, please.
Go for it.
Again, thank you, Mrs. Hill, for bringing this before the board. Ms. Bramo, I really appreciated it. I'm personally very excited about being an advocate for continued education, particularly for vocational training. And it seems like a correctional facility is the perfect opportunity. And I've mentioned to our executive director that I'm more than happy to be very supportive and be your lead supporter for continuing education requirements. This is not a new concept. I'm sure that Alex Forbes started cosmetology training in the Caliente, the girls' reformatory, back in the 70s. So it has already been in the state of Nevada, and I want to honor his presence too, that he was a forerunner in this, and to kind of lead into what Gary was saying, because there was a question about the licensees or the students becoming licensed, and that there's actually no guarantee for any student in a cosmetology program that they would be ending up being licensed after testing. So we don't provide guarantees to any of our potential students or potential licensees. I also want to make a point, too, that we do have an NRS law, 644.437, and that concerns the marketing to a specific gender. And so that will be an additional concern for me to make sure that that we do give opportunity for a men's correctional facility in addition to a women's correctional facility. So we always are following the intent of the law. So while this particular law doesn't necessarily impact the marketing for services within a women's correctional facility, I do like to point out that it will be something that will be a little obstacle, perhaps, as Mr. President referred to earlier, if there were any obstacles. I also wanted to address Mr. Landry's question about our comments about scoring higher. It's not just scoring higher that we want the students to excel in, but equally as important is staying in the profession, longevity. And it will be nice to have such a reputable school encouraging the potential licensees to have a lifelong career and a lifelong journey with cosmetology. And of all the schools, I'm thankful that your school has such that commitment already to your existing students, and it will be a really nice partnership to welcome that.
Thank you.
Thank you, Mr. Leader. Any other comments by board members? Would there, I'm wholeheartedly for this as well. I think this is a great idea, and I hope our legislators see it that way as well. Do we need to create a motion that allows Mr. Landry to support and move forward? Since this wasn't something that we did last meeting, we gave him our bills, our changes. So I would welcome an opportunity to have a motion made that assists Mr. Landry and gives him direction from the board.
Mr. Vice President, I'd like to propose a motion to the board that we wholeheartedly support this and authorize Mr. Landry to take whatever means or actions necessary to continue to promote this so that the legislature understands that we as a board think that this is important.
I'll second that.
All right, having a motion and a second. Any further discussion? I'll take a vote on that. All in favor, say aye. Aye.
Aye.
Aye.
Aye.
Aye.
Any nays? Seeing none, motion carries. All right, Ms. Hill, thank you very much for your information today, and we hope and wish you the best in the future, and we hope this all goes through and works out well for you.
Thank you. Have a good day.
Thank you. Okay, so I'm going to call this meeting. I'm going to cause for a break at the moment, and when we get back from the break, this would be the time when I'm going to pass the gavel to someone in Las Vegas so that we can do the formal complaint hearings. Is there any objection to that?
Sir.
All right, so then we're going to take a break here. It's 9:40. Be back in about 3 or 4 minutes. Is that enough? Or do we want to do 10?
Let's just do 5. Is that good?
5's good. All right, 5 minutes. We'll be back at 9:46. All right, so we're getting close to that time to reconvene. Who is going to be taking the gavel down there?
I believe that Mr. Leader is taking the gavel.
Excellent. All righty, so I will call this meeting to order at 9:48 and turn the gavel over to Mr. Leader for the formal complaint hearings.
Mr. Nixdorf, thank you. If you find that this process doesn't meet your satisfaction, then just kindly let me know, and I'm happy to turn it back over to you.
I have full faith in you, Mr. Leader.
At this time in the agenda, we're at item number 11. It is a formal complaint hearing. Are all of the parties present for Why Me Hair and Nail Salon, license S11116, case number C14922? Are all of the parties present?
Mr. Leader, I'm not sure if the respondent will be present because I believe they have surrendered their license, but I thought we should call for them just in case because they were noticed.
Would you like me to give them the opportunity to, we'll cover the other ones that are on the...
No, I don't think we need to do that. I kind of am expecting that they will not be here.
And would you like to hear any part of the case at this time? Or?
I would, so I'm guessing there's no one here from Why Me Hair and Nail Salon? Okay. Mr. President, what I would like to do is ask that the board decide the case in the respondent's absence after we show that they've been given proper legal notice of today's hearing, and then I have a proposed resolution for the case as well.
Is there any discussion by any board members for that recommendation that we proceed according to Ms. Bradley's recommendation? Any concerns or questions? So the board then will consider a complaint under this case number C14922. And for those of you not familiar with this process of the complaint hearing, I would normally give you a brief overview. It sounds like that might change based on Ms. Bradley presenting the side of the case and then presenting possible options. So in lieu of saving time, I'll review this on the next complaint if necessary. Ms. Bradley?
First, I'd like to make an offer of proof that Why Me Hair and Nail Salon was given proper legal notice of today's hearing so that we can proceed in their absence pursuant to NRS Chapter 622A, which allows the board to proceed if someone has been noticed and has not appeared.
Ms. Bradley, two folks have just come in, though. Are you with the Why Me Nail Salon?
No, we're not.
Okay. Are any of you who are straggling in? No? Okay.
So in my offer of proof, I have a copy of a certified mailing receipt as well as a signed green card that I would like to admit as State's Exhibit 1.
So admitted. And if that could go to Ms. Bradford. Now that the board members have had the opportunity to review evidence of the proper posting, may I have a motion?
And I also have the certificate of service if you'd like. I should have included that with that.
And we can combine those in
Yes.
this? Okay.
So just for the record, those should both be number 1 then. There's just 2 pages to number 1.
And again, board members, now that we've seen that evidence of proper posting and certificate of service, may I have a motion to accept that notice was properly posted, or notice was
I
properly
propose a
provided?
motion that we accept exhibit as authentic from Ms. Bradley.
I'll second.
One moment.
My motion is to propose that the respondent, I guess it would be, was properly noticed and notified of the hearing today.
I'll second with corrections.
Okay. Are there any questions or comments or discussion regarding the corrected motion and second? All those in favor?
Aye.
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 Any opposed? Ms. Bradley, that motion carries. You can proceed.
Thank you. Let me just look up the provision so that I can cite to you.
Ms. Bradley, are you looking for a provision in 622A?
Yeah.
It's 622A.350 in the NRS, the effective failure to appear. Would you like me to read that?
That would be fabulous.
I'm Rosemary Reynolds. I'm here acting as board counsel during the disciplinary hearings. If a party fails to appear at a scheduled hearing and a continuance has not been scheduled or granted, any party who is present at the hearing may make an offer of proof that the absent party was given sufficient legal notice. Upon a determination by the regulatory body or hearing panel or officer that the absent party was given sufficient legal notice, the regulatory body or hearing panel or officer may proceed to consider and dispose of the case without the participation of the absent party.
Thank you. And so given that the board has now deemed that proper legal notice of today's hearing was given to Wyoming Nails, I would ask that the board find that all of the facts as alleged in the complaint and notice of hearing have been proven. And for the record, that would be facts 1 through 16, as well as that the violations of law, and there's 3 claims for relief, that those have all been proven.
Have all the board members had the opportunity to read the factual allegations 1 through 16 as presented in our packet, including the violations of the law? There's 3 claims for relief. Are there any questions? I'd be happy to entertain a motion to find that the factual allegations are in fact true and accurate. Is there a motion?
I make a motion that the findings are accurate.
Is there a second?
I'll second that.
I second.
Thank you, Mr. Nixdorf. Is there any discussion, questions, or comments regarding the motion or the second? I'll accept a vote. All those in favor, please say aye.
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 Any opposed? And that motion carries. I'd like to now move to the violations of the law. Is there a motion for, do I need to do each one, or can I combine the 3 claims? Okay. So given a recommendation that the 3 claims for relief, is there a motion that accepts those violations of the law?
I make a motion that we accept the 3 claims of violation of the law.
To clarify, you're stating that those claims have been proven?
And I'd like to amend my motion that they have been proven.
And thank you. Is there a second?
I'll second that.
Thank you. There is a motion that the violations of the law, and there are 3 claims for relief, have been proven. There is a second. Is there any discussion, question, or comment? I will ask for the vote. All those in favor, please.
I have a question. Ms. Bradley, you said these people have surrendered their license. What effect will that have on these claims?
Well, I have a proposed resolution for you once you get to, once you found the facts true and the violations true, then when you get into the penalty phase, I have a recommendation. It's how we handled a previous similar case. So I would ask that you do that then.
All right.
All right. Thank you, Mr. Nixdorf. There is the motion. Any other discussion, questions, or comments? There has been a second. All those in favor, please say aye.
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 Any opposed? And that motion carries. And finally, we're in the disciplinary stage, and there's two portions to the disciplinary stage, and I will just turn this over to Ms. Bradley for her recommendations for discipline.
Thank you. So we had a previous case that was similar in that by the time the case got to the board, the salon had surrendered their license. So I would ask that the board accept a voluntary surrender of the respondent's license as the penalty for this case. And in that previous case, what we also did was we said that any future application for an establishment license with that owner named would be denied by staff, and then they would have to come before the board for approval. So what I'm asking that you do is accept the surrender of Waimea Hair and Nail Salon license number S-11116 and Thao P. Tran, it's T-H-A-O-P Tran, T-R-A-N, that's the named owner. So I'm asking that you accept the surrender of the license as the penalty in this case, and then also with the caveat that if that owner ever reapplies for a license, they'll be denied by staff and they would have to come before you to be relicensed as a salon owner.
Sarah, could I ask, is that person also a licensed cosmetologist or?
You know, I don't have that information. The complaint doesn't notice it that way. So, and it's really just against the salon here. Okay. So,
thank you. Any other questions or comments?
I have a question. If this is now the second time that we're going to be doing this, are we setting a precedent with people that just turn their license in and don't have to be held accountable for violating the law?
Well, this is a penalty. A voluntary surrender of a license is essentially an agreed to revocation. So what we're doing is we're saying we'll accept your surrender of your license, but you're not going to have any other penalties, but it's essentially a revocation of a license. They're just agreeing to it ahead of time. Normally speaking, I would prefer that the person contact me and we decide this and we have them sign an agreement. I have a voluntary surrender of license in lieu of other disciplinary action agreement they can sign. But sometimes people want to do it ahead of time. And in this case, I believe that the owner relocated to Oregon, but I could be incorrect. But I think the person relocated and just wanted to close shop.
Well, my concern is that if somebody just quickly throws the license on the table and says, I'm going to walk away, it doesn't make any sense as a business owner to do that unless somebody else can take their business over and all that stuff. So are they just getting away with it by doing this as opposed to actually being held accountable by us as a board?
I mean, I would say that, again, there's a record of the discipline. It goes in their licensing file. This is something that's done in many other professions. We allow people, especially if they're leaving the area or the business, we allow them to surrender a license. It's still counted as discipline. And like I said, we consider it essentially an agreed to revocation. So it's, to me, it's a very serious discipline.
I just was curious that we're setting a precedent by allowing that instead of getting after them.
Ms. Bradley, do we have some assurance that this particular licensee hasn't used reciprocity to gain a license in I think you mentioned Oregon?
This action is against the salon and not against the licensee individually. So there would be no, I can't answer that question. I don't have the facts in front of me as far as whether they've applied for reciprocity or not. But if they do, this would not be on their personal license. This is on their salon license. If they went to open up a salon and another state would ask us about it, which doesn't happen, just so you know, it's just strictly at a personal license level is where we usually work with reciprocity.
So the answer to your question is yes. They went to Oregon, got a license, and are doing services up there, and probably potentially injuring the public just like they were trying to do here.
But this isn't against
Yay.
a personal license. This is an establishment license. And the record is there. So if anybody in any state asked the board, do you have records on this salon? The board would provide them. So this information, a voluntary surrender, would be public information available to any state.
Right, but as Mr. Landry stated, it's a establishment license, not an individual license, so the individual can go and apply for a license and skate away with it and go do bad shit up there, pardon my language.
Well, and I think what he's saying is that the establishment license would have to be under Why Me Hair and Nail Salon. In the using reciprocity, he would have to use the same salon name or establishment name.
No, that wouldn't be the case. There would be typically there is no reciprocity for salon establishments. There's only reciprocity at the individual license. So you can have a Why Me Nails in every state of the United States if you want to. Just there's not a reciprocity agreement between states for salons. It's only at the individual license level.
I mean, we don't know why boards don't ask this, because it would be good practice, in my opinion, if I know someone's coming from Oregon, to ask for all records regarding them, not just their personal establishment. I mean, they can ask for that information and we would provide it, but normally reciprocity is just on the individual license. But I guess what I'm trying to say is, in many professions, it would be standard to say, I want all records regarding John Smith that you have at the board office, including their establishment and personal license. And then the other board would review them and maybe deny an application based on, good moral character, because you've been essentially voluntarily surrendered, and which is like a revocation in another state. So another thing is, most applications say on there, have you had previous discipline in another state? The person should be honest. And if that person asks this board will say, yes, there was a previous discipline. So, I mean, it can affect the person in another state. It just depends on what the background check that other state does, and if the person's honest or not, and how that state would then treat this.
You.
So basically, in this fairy tale, there are no disciplinary actions for this particular person, because we don't practice that due diligence in our protocols, do we? We don't ask for other.
Currently, we do not.
Right. So I disagree. I don't think that that's enough by just revocation of license. I think that there should be some sort of mandated education that goes along with this, or something if they're going to be, or some sort of fine.
Ms. Benaldi.
I have a question too.
Oh, Ms.
That goes along with what Ms. Benaldi. If I understood Sarah correctly, and I think we're missing this piece, is that person's name, they can't open up a business, whoever this person is, they cannot open up a business in any other name. Is that correct? Did I understand you correctly?
If they come back to your board, so they're in Nevada, and they say, we'd like to have an establishment, and if this name is used, the staff will deny the application, and then the person will have to come before you and explain what happened in this situation and why they should be relicensed and how they've learned their lesson.
Sarah, is it the name of the person or the name of the salon?
It's the name of the person, because they can change their salon name very easily.
Correct. That's what I wanted to find out.
Yeah, so it's going to be tracked by the owner. That was owner of record, which is the THAOP Tran. That's how it's going to be tracked. And I understand that you're unhappy about this, but the person isn't here anymore. I don't know how we're going to collect a fine and or require education of a person that's no longer in the state of Nevada.
Ms. Benaldi, is there a possibility of including the costs of today's hearing into a motion where accepting the actual surrender?
Well, I think it would be prudent to have a fine attached to that person's name, so if they do come back into the area, it would red flag them, and they'd have to come back.
I would tell you that staff's recommendation is that you accept the voluntary surrender and that no costs are assessed. This is exactly how we handled the famous Nails case, and this is consistent across state boards and how these sorts of matters are handled.
Thank you, Ms. Bradley. Is there any other question or comment?
I know this is kind of mundane here, but do you use their social security number? Is that tied to their name, and their driver's license tied to the name?
That's how we identify an individual by Social Security. That's the only unique identifier that would tie someone's name, because there are many trans. There are many, Gary Landrys in the world.
Right.
But the tie-in between the Social Security and the name is how we identify a unique individual.
'Cause I would hate to see this person back in Nevada under a different name doing work. I mean, I find that appalling.
Thank you, Ms. Booth. Mr. Nixdorf, did you have any questions or comments?
No, I think everything was covered by everyone else.
Thank you. At this time, if I could entertain a motion to accept the license surrender for S11116 as the disciplinary action in this complaint.
I'm going to make a motion for the license surrender. Is it okay if I make the motion? I'll hold my motion for a moment.
Thank you. Ms. Bradley, you provided staff recommendation, and Ms. Booth, I know that there's a motion on the table, so I would need a second, or I could ask you to redact your motion. And if Ms. Bradley, if you could just kindly repeat the staff recommendation to include both parts of the license revocation?
The recommendation would be that the voluntary surrender of respondents' cosmetological establishment license S11116 be accepted as resolution for this case. And for the record, the name of the owner is THAOP Tran. And so we would ask that the voluntary surrender of that license be accepted, as well as that if that owner reapplies for any future establishment license, that application would be denied, and the owner would need to come before the board for review and possible approval of the application. And again, we would also ask that no fines or costs be imposed. We would ask that this be the sole resolution for this case.
Thank you, Ms. Bradley. Ms. Booth, would that be the intent of your motion?
That is the intent of my motion.
And so we can use that for your motion?
Please.
And is there a second? Is that motion going to fail?
I'll second.
Without?
I'll second that. Basically, we're
Thank you.
Your motion was to accept the recommendations of the Attorney General's office, correct?
For the disciplinary action for this licensee?
Yes.
Yes.
Yes, that is correct.
All right, that's what I'm
and
seconding.
So thank you, Thank you for the second. And is there any question or comment or discussion? Any comments regarding fines or costs? I'll ask for the vote. All those in favor, please say aye.
Aye.
Nay.
Nay.
Nay. Will the nays please raise their hands? And will the ayes please raise your hands? That vote is 4-3. Oh, no, 3-3.
It's tied, so the motion fails.
So that motion fails. Arrgh.
Would someone like to bring forward a new motion?
Mr. Nixdorf, was that your
Yeah,
suggestion?
that would be my suggestion, is that someone of the opposing thought process bring forward a motion of their own to see if they can get that passed.
If you like, I could also put forth testimony from the inspector to tell you more about the case that brings you before the board today. In other words, they can tell you, I think, whether or not it was an egregious violation or what their recommendations are, because this isn't just the Attorney General's recommendations, this is also staff's recommendations. So what I'm bringing to you is what the inspection staff and Mr. Landry believe would be an appropriate remedy for the case. And so I'd be happy to bring them forward to talk about what they saw that day, if that would help you determine the appropriate penalty.
That would help me.
I would imagine if Ms. Ball wants to step forward and talk to us, that would be a way to further clarify it.
So we're going to receive testimony from a staff member. If you could please just remind us of your name and be sworn in.
Diana Ball, Field Inspector 1.
swear or affirm the testimony you're about to give before this board to be the truth and the whole truth and nothing but the truth?
I do.
So would it be appropriate for me to ask Ms. Ball some
Oh,
questions?
yes, please, definitely.
Ms. Ball, when you did the inspection of Wyoming Nails, do you recall what you saw on that day?
I do.
Can you tell us about that?
I observed and took photographs of used, single-use instruments, nail files, buffers, sanding sleeves, at nail stations and on rolling carts at the petty spas.
And can you tell us when the previous violation was? Do you recall how much time had passed since that violation occurred?
There was a warning issued on a routine inspection on 9/27/2012. Then on July 24th, 2013, Ms. Fitzgerald performed a routine inspection where she issued the first citation for used single-use instruments. On a year later, 7/14/2014, I was performing a routine inspection when I observed the same offenses that had a citation written for before. The cosmetologist in charge at the facility came to board office on July 22nd, 2014, and delivered the infection prevention measures he had activated in the salon. He gave exams to all his employees, had them sign that they had received them, that they had passed the exam. That was his way to make sure that the salon, that the employees in the salon understood the laws.
And is that something that you've seen other salons do in resolution of cases like this?
I have, actually. The next salon coming up has done the same thing. And then on 8/21, there was an application turned into the board to change ownership of the salon. The same cosmetologist in charge is present in the salon. On 9/4/2014, we issued a new establishment license to a new owner. And on 9/8/2014, Mr. Green conducted the first inspection, found the salon clean, tidy, in compliance.
So are you comfortable with the voluntary surrender of the license for the previous owner as resolution of that citation?
I am, with the recommendation that staff reviews any application or denies any application turned in by the previous owner, and they would have to come before the board.
And is it fair to say that the procedures that cosmetologist put in place and the testing that impressed you, that they were serious about making sure the rules were followed going forward?
Absolutely.
Thank you. I have no further questions for Ms. Ball.
Are there any questions for Ms. Ball?
Do you know by chance if this Tao Tran is a licensee?
She is.
And Ms. Curtis, as Chief Inspector, did you have comments or questions or concerns? Did that help to reframe the motion, or would we like to have a board member entertain the first motion?
I have one other.
Given?
I have a question.
Thank you, please.
Mr. Landry, should we impose a fine upon a business that no longer exists, will it be possible to collect on that, do you believe?
So in a practical sense, no, I do not believe we will collect that, but we will incur a cost in having to track that, but I don't see any way that we would collect. We don't have jurisdiction in another state is our problem.
And theoretically, the business license that person had would probably be no longer in existence either, since that person's no longer in the state, or theoretically no longer in the state. So that would mean that we would be imposing a fine upon a non-existent entity. Am I correct in that?
That I can't answer because that's handled through the Secretary of State's office. We don't have knowledge of the validity or the activity on any particular state license. We can look it up. I mean, the Secretary of State's website allows us to look that up, but we don't. I'm not aware of what the status is of Ms. or Mr. Tao Tran's business licenses.
But as far as we're concerned, once they've relinquished the license, they're non-existent to us except as history, correct?
That is correct.
I propose a motion that we reconsider the previous motion before the board by Ms. Booth. As much as my previous vulgarity let out I am displeased with this as a course of action to just surrender the license and be able to get away with it, but we don't have another choice.
Well, be careful. Ms. Bradley also indicated that there was an and the first motion reflected the entirety of Ms. Bradley's staff and administrative recommendations. And so there was an additional penalty for making the licensee's reapplication subject to review, if I can
If she
paraphrase
actually
that.
comes back to Nevada and becomes part of our jurisdiction again, which...
Right. So there is a motion on the table, which you've made, Mr. Hoffman. Is there a second?
I'll second.
And there is a motion and a second. Any other question, discussion, or comment? I didn't mean to cut you off, Mr. Hoffman.
Yes, you did.
Mr. Nixdorf, not to overlook you, any question, comment, or concern?
No, I'm good.
With the motion on the table, all those in favor, please say aye.
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 Any opposed?
Aye. Reluctantly.
Nay, you mean? Or aye? Oh, okay. And then aye for me. So were there any nays? None. That vote passed. And Ms. Bradley, there's an order, is that correct, that is prepared to notify?
Yes, I will prepare the order and send it to Ms. Bradford, and she'll obtain the president's signature on it before it's sent out.
Thank you. Moving right along to item number 12,
Thank you, Ms.
Nails.
Ball.
Jan He is Lucky Nails present? Are all the parties present for item number 12?
Actually, in this case, Mr. President, we have a settlement agreement that we would like the board to approve, and I do have copies of that for the board. And I do apologize. The signed copy was received in the Reno office, but we just didn't have time to get copies together for you. So we do have a signed copy from the respondent, and what I'm going to give you doesn't have any signatures on it yet, but this has been signed and agreed to by them.
Ms. Bradley, do you need to hear the facts of this case and determine whether the violations of the law were accepted prior to?
No, the settlement agreement has everything agreed to in it. So we are going to pass that out for you just to make it easier, maybe a little simpler for the board.
Ms. Bradley, I'm going to interrupt you. Mr. Nixdorf, you're not necessarily receiving this copy. Is there an opportunity for Mr. Nixdorf to receive this copy?
I believe
There
I'm
is,
getting
and
a
I
copy
wanted to
right
also.
now.
Okay, great.
Is that's correct?
And I also wanted to,
so I have
just
a
to
copy.
save you guys some time save you time in reading, if you look at the stipulation for settlement of disciplinary action, so the parties are the board and the respondent, which we already had in the complaint. The alleged facts are the same as in your complaint and notice of hearing. So if you've read that complaint, those facts are the same. The person agreed to those facts. And then the alleged violations are also the same. The person has agreed that the violations did occur. So the new part really for you starts on page 3, and that's the proposed settlement. And so that's all of the things that we've agreed to. And the summary is, and this is the part you're probably mostly concerned about, so they've admitted all of the alleged facts, they've admitted the violations of law, and then they've agreed to pay a fine of $200 per violation of law as alleged above in the first, second, and third claims for relief, for a total assessed fine of $600. That fine must be paid within 90 days of the order approving the stipulation, because I do still prepare an order that is sent to them.
Do any board members have questions or comments regarding this proposed stipulation for settlement of disciplinary action regarding license S11790?
I do, just to make sure I understand. We oppose a $2,000 fine, and you're trying to settle it for $600?
You did not impose any fines. You just have a max of $2,000 per violation that the law allows you to do. And so normally we don't impose the max fine right away unless it's very egregious. So board staff has recommended that the fine in this case be $200 per violation for a total of $600. So previously the person paid a $100 fine in the NAC, as set forth in your NAC, and now they're going to pay $600. So it's still quite an escalation from the previous fine. And again, this is board staff's recommendation because they do not believe that the violations here were egregious as they have been in some cases. But if you like, I can bring forth an inspector to give you testimony about that. But really, this shouldn't be that way. This is a settlement. They've already agreed to everything.
You can't bring the inspector forward. She no longer works for the board.
Are there additional questions, or are board members inclined to hear from another inspector that may have relevant information regarding this alleged violation?
May I interrupt? When you're presented with a settlement agreement, your vote is pretty simple. You're either going to accept or reject the settlement agreement. There really isn't an opportunity for you to ask any factual questions, which you might get into if you were to, for example, call in another inspector. They've already accepted the facts as proven. You've got those in your settlement agreement. So it's pretty simple. If you're unhappy with the settlement amount, then your vote would be to reject the settlement agreement and actually hear the case at another meeting.
Do all the board members understand that directive?
I'm stuck on one thing, and I'm the public member, so it may be the reason why, is why did we go to settlement with these people?
Because they contacted me and asked me to do that. They wanted to settle the case and not have a hearing.
And so that means that they accepted guilt.
Yeah, it doesn't always happen, but
I was going to say, this was the first time for me.
It's unique. We've had it happen probably 4 or 5 years ago, the last time it did. But in this case, they were very diligent. They called me at least 3 times wanting to settle this. And so then I conferred with Mr. Landry, and that's how we came up with the settlement that's before you. So it is unique. In the complaint, if you look at the complaint that we give them, every complaint that I send out says, if you want to settle this case, I think it says for informal, I don't know, it says something else, but basically it's saying if you want contact for settlement, has my name and phone number. And this is the first time that someone's actually called me directly. Normally they go to the board office and then they're referred to me. So I was sort of impressed that they read the complaint and called me. And like I said, Mr. Landry and I talked about it, and that's how we came up with the dollar amounts and all the things that you see in the settlement.
Thank you, Sarah. Like I said, this is the first time for me, so I needed to understand it.
Thank you, Ms. Booth. I appreciate your clarifying some of that information for us. Is there a motion to accept the stipulated settlement agreement?
I make a motion to accept the stipulated agreement.
Is there a second?
I'll second that.
Oh, thank you, Mr. Nixdorf. Ms. Benaldi seconded that motion. Any question, comment, or concern? There is a motion on the table to accept the stipulated settlement agreement as written. All those in favor, please say aye.
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 Nay.
And 1 nay. Ms. Tran. That motion carries. Item number 13, the formal complaint hearing for alleged violation of NAC 644.340 with Regal Nails, license S11460. Are Regal Nails present? Please step forward. At this time, for those of you not familiar with the process, if you could please have a seat, I will present just a light overview. You're considered the respondent representing the establishment. Is that correct? So I'll have you please stand and introduce yourselves and spell your names for our court reporter to accept that what you will say is truthful and under oath.
My name is Pham, and Pham, P-H-A-M. I'm the owner of the Regal Nail.
Thank you.
My name is Rosie Pham.
I'm just helping her translate.
How do you spell your first name?
Rosie and Pham, Pham.
Thank you. I'll take a, oh, please.
Will you be giving testimony?
Testimony, I guess.
Okay, if you both stand and raise your right hand. Do you, each of you, solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth? Thank you.
At this time, I'll just explain the procedure for you quickly. Okay. Deputy Attorney General Sarah Bradley will present the board staff case, and she will enter exhibits into the record and call witnesses to testify. And after that testimony by each of the witnesses, once that's been completed, you'll have the opportunity to ask questions of that witness or those witnesses. And then the board will have the opportunity to ask questions of those witnesses. At that time, you'll be given the opportunity to call witnesses of your own, and they can testify and enter exhibits into the record on behalf for you. These additional witnesses, once they've presented their testimony, then the Deputy Attorney General will be allowed to ask them questions. And then finally, the board members will be asked to will be allowed to ask questions. And finally, Ms. Bradley and the respondent will make closing arguments one after the other. That public evidence portion of the case will then be closed, and board members will deliberate that case. There will be motions made, and that may result in disciplinary action and/or fines. And then a vote will be taken by the entire board. Are there any questions about that summary of the procedure that you might have? Any questions or concerns? I know I went through that quickly for you.
No, we have read through the sheet that was provided for us.
Okay, and so are there any other witnesses or parties that are going to present evidence for you or on behalf of your mom?
We are here to not contest the allegations.
Okay, so
we're just here to come into the board to apologize for the actions, and that we have turned in our actions for, to just re-educate our employees, and to make sure that everyone knows that we are serious about, all of the allegations, and we want to correct all of the things that, that were found.
Well, let's take a listen then. And so if that's your position, why don't we hear from Ms. Bradley, and we'll go ahead and proceed.
Thank you. Well, what I'd first like to do is admit the exhibits. So let me confer with the respondent, make sure they agree to the admission of the exhibits, and then perhaps we can stipulate to the facts as well on the record.
I have 5 exhibits, and so agree. The first one is just the complaint that you have, and then the second one.
Oh, that's nice. Oh, that's great. Super sweet. That's so nice. Although you
copies that I can give you for your records too.
Well, we're ready for us to be more.
5. This is the previous citation, which is why you have to come before the board, because you had one already.
Right.
And so those. So if you want to agree, we can admit all of those into the record right now. They've seen this, but they haven't seen anything else.
Okay.
So if you agree with that, I will ask you, and then you can put that on.
Okay.
Okay.
So I have just conferred with the respondents, and they do agree to the admission of exhibits 1 through 5, but I would like them to just say that they agree on the record.
Yes, we agree.
There's a microphone button, yeah.
Yes, we agree.
Thank you. I don't know if it's picking you up. So Ms. Bradford is now giving the respondents the exhibits as well as all of the board members.
And Mr. Nixdorf, are you getting a copy of these exhibits? Thank you.
Yeah, I was going to say, if it helps in Carson City, you can just give Mr. Nixdorf 1 through 5 right now. I know we had them separated, but.
And so that's so admitted?
Thank you. So I think I'll wait for a second while the board members receive the exhibits.
So then this is just two.
Sometimes that's what I do in cases like this where you just want to come and just say. Other cases prior to us have. We've had
Mr. Nelson, do you need copies of these also? Okay. Makes you want to go get your hair done, huh? You know why you shave your head. Right. Do you have like that? I mean, I'm not trying to be rude, but. Mr. Nixdorf, just to confirm that you've received all 5 exhibits?
Yes, I have.
Okay. Did you have any questions or concerns before we begin, or are you good for just listening to the next part of the disciplinary hearing?
I'm good just listening to the next part. It's all good.
Okay. Thanks.
So I have conferred with the respondent, and they would like to stipulate to the facts and the violations of law as contained in the complaint. I would like, though, their verbal agreement on the record, just so the record's clear. So they have agreed that they stipulate to the factual allegations in the complaint. The factual allegations start on page 2 and finish on page 3, and they have agreed that factual allegations 1 through 17 are true and correct. And I can read them into the record if the board would like, but I think since you have them in front of you, that's probably not necessary.
Is every board member comfortable with reading the factual allegations 1 through 17 rather than reading them into the record? Just having your exhibit part of the record? Everybody? Okay. No concerns? Great. Thank you.
So can we have their verbal agreement that 1 through 17 are proven and did occur?
Please.
Yes, we agree.
Without exception?
Yes.
Thank you.
We've also conferred and we agree to the truth of the violations of law as contained in the complaint. The violations of law occur on, starting on page 3. That's where the first claim for relief is. And then there's a second and third claim for relief on page 4. And they do agree that those violations did occur as well.
Yes, we agree.
Okay, without exception?
Without exception.
Okay. Any board member have any questions or concerns regarding the allegations, the factual allegations and the claims of relief being proven by expressed by the respondents?
Can I put something on the record when you believe it's appropriate?
Please.
Okay. So the reason that they have agreed to these violations is that they would request that the board be lenient, and they are throwing themselves on the mercy of the board. They have also instituted some procedures, as Ms. Ball can testify to, regarding how to ensure and train that employees don't do this going forward. So they have instituted some new procedures and policies going forward, and that's part of the reason that they are agreeing to these, because they're hoping that you'll take that into account and that the penalty will be reduced. So whenever you think that's appropriate, we do have that information to give to you.
Okay. So at this time, board members, I am going to ask for a motion that the factual allegations and the claims of relief have been proven by admission. Is there a motion to that effect?
I make a motion to that effect.
And is there a second?
I'll second.
Thank you, Mr. Hoffman. Is there any question or comment or discussion regarding that motion? All those in favor, please say aye. Aye.
Aye.
Aye.
Any opposed? And that motion carries. And now we'll enter the disciplinary phase of today's hearing. And Ms. Bradley, I think you may have been offering a recommendation.
Well, staff does not have a recommendation for a fine in this case, unless Ms. Ball would like to provide one. I don't have one, but I would say that the reason that they have agreed and stipulated is that they're requesting that the board take into account the subsequent efforts they've made to change things in the salon, and they are throwing themselves on your mercy rather than contesting the allegations and having a longer hearing proceeding. So they're hoping that that will be taken into account when you make your decision. And I believe Ms. Ball has more detailed information regarding those procedures that she's prepared to tell you about.
Thank you. Ms. Ball, did you want to make some public comment, please?
Yes, I have the proposed correction procedures that the salon has implemented. I'd like to go back from the start. On 9/25/2012, routine inspection of the salon, I issued a warning about used files and buffers, single-use instruments that I observed at the time. Ms. Fitzgerald was back in the salon approximately a year later, July 2013, where she observed used files and buffers again, and she issued the first citation. She also noted that there were used wax sticks on top of the wax pot at that time and educated them that wax sticks are to be thrown away after touching a customer. At a routine inspection on 6/12/2014, I again observed used files and buffers. I noted some other things on the inspection report as far as proper sanitation solutions, proper storage of instruments, and I actually observed an entire brow wax using the same stick. So I wrote the second citation at that time for the single-use instruments. Then I received from the salon on 6/26/2014 their corrective actions. They note here that in regards to single-use items, we've changed all files and buffers to single-use sized items. We've also re-educated all of our employees about single-use items. And if caught reusing a single-use item, they'll be given written notice of warning upon first offense and terminated upon the second offense. We take the safety of all our clients and employees very seriously, so it will continue to be vigilant about this matter. A little concern with me on this is that I don't really hear the single-use wax stick noted. So I would like to be sure that they understand proper use of wax sticks.
And do you?
Okay.
And you have what she's reading, a copy of what she's reading? Yes. Would you mind just making that note so we can have some assurance that that will be corrected in the future? And to include, I'm sorry, Ms. Ball?
Then they noted the training on proper use of storage of instruments. that are not single-use. They address the disinfecting, sanitizing solutions, and proper education to all employees about cleaning the petty spas. I have signatures from every employee that they've got the policies and procedures, they understand, they'll follow. So that's where we're at now.
Thank you, Ms. Ball. I appreciate
You're
that.
welcome.
So it sounds like just with that minor correction that the inspection department is cool with the recommended changes in their protocols.
I have a question as well. What were those dates now that you gave, the first dates that you gave me? Okay, thank you. But once a year.
Can you say those dates into the record again, just so it's clear? I just want to make sure that Mr. Nixdorf knows, because he doesn't see that paper.
The initial warning was issued 9/25/2012. The first citation was written 7/9/2013. Second citation 6/12/2014. Their corrective measures were received 6/26/2014.
Thank you. Mr. Landry, what is the customary or the legislated fine that's appropriate to this particular matter?
There is no legislated fine for this particular matter because it is a second offense for a sanitary violation. The NRS 644-700 only, NAC 644-700 only stipulates a $100 fine for the first offense and stipulates no other fines for subsequent offenses. So that was recently corrected by board action earlier today at a public hearing, where it will be 100 for first and subsequent. If we find violations that are egregious or that we don't think the salon owners are heeding our warnings, then they would be brought before the board for a hearing similar to this.
Okay. Any other questions or comments regarding this matter? Please, Ms. Booth.
My question is to the respondent. Why wasn't this done the first time you were cited? Why did it take three years to get the message? My concern is that, are we going to get a little lackadaisical by the end of next year? I'm seeing a pattern of once a year being cited.
We felt that we had corrected the actions with our employee, but those previous employees weren't following the procedures that we were implementing. But this time we know, because we don't want to end up here again in front of you to, do this ever again. And so, we are ever more serious about taking actions towards our employees when they do, don't follow the rules in our salons. So
I have one other question. Are you or your mother in the salon every day? Who's overseeing these people so that we can be assured that they're not going to be doing this again?
My mom is actually the one that she works on and off to, it's either her or my dad that manages the store. So on days that she's not there, then he will be there to make sure that everyone is following the rules correctly.
And who was in the past, back in 2012, who was overseeing the salon then?
I believe it was our cosmetologist in charge.
Barbara.
Barbara Tran.
Okay.
One of our employees there.
Okay, and then in 2013, who was overseeing then?
Also Barbara.
Okay, thank you.
I have a question.
Thank you.
Ms. Ball, am I correct in assuming that these are not consecutive inspections, that there were inspections in between these violations that they passed?
I'm sorry, I don't have that information here with me.
In theory, you would have been doing it every 3 months or so, right? So it would have been at least one inspection or two inspections in between some of these where there were no violations. Would that be a correct assumption?
I can't speak to that. I don't have the information here.
Mr.
Okay.
Nixdorf, would you like that information retrieved prior to making a decision? Or would you accept that there may or may not have been?
It sounds, that like each inspection had a violation, and I'm not so sure that that's necessarily true. I don't know that that would make a difference for me, so I'm not going to press that matter.
Thank you. Is there any other question or comment, or could we proceed with a motion? Ms. Bradley, did you have any final comments before the board proceeds with a motion to accept the disciplinary action as recommended?
You've already found the facts and the violations of law. Now it's just a matter of you determining what the appropriate discipline
Doesn't
is.
have any comment
So
to that
I
effect?
don't have a recommendation on that. I would just ask the board to remember previous cases and try to be consistent with how we've handled the previous cases and how we'll handle things going forward based on the new change in the law.
And Mr. Landry, does staff have a recommendation for the assessed fine or penalty?
Staff does not have a formal recommendation, but as Ms. Bradley said, we just had a previous case very similar for sanitation violations with the stipulated settlement of $200 per violation. That that would seem appropriate in this instance as well on a being consistent, consistency basis.
Is there a motion?
I just have one question. I have one question. Is there 3 violations? Okay, I just wanted to confirm I was understanding that correctly. Thank you.
And did you have any questions or concerns prior to the vote? Did you have a recommendation? I asked the Attorney General if she had a... Pardon me?
I'd like to make a motion.
And then I asked Mr. Landry, but did you have any comments on... Okay. Mr. Nixdorf, please.
I'd like to make a motion that we assess a fine of $200 for each of the 3 violations. I don't think I have to make more than that, right?
So there's a motion on the table, and there is a second. Any questions or comments or concerns? And so just to reiterate that motion, Mr. Nixdorf, you understand that that would be a total of $600?
Correct.
And is the second, do you reflect that total amount? Absolutely. Any other discussion?
Well, I just have one comment, and that is I applaud your honesty and your integrity coming forward. That shows I really respect that. Otherwise, I would be pushing for more of a violation and a fee to be, imposed. So I just want to thank you for that. I really respect that.
I also wanted to add to that. I agree with Ms. Bonaldi. I really appreciate the integrity that you've come in. There is also an opportunity for the board to impose the costs associated to this hearing, and that is not included in this motion. And so this does reflect leniency in terms of our ability to extend a disciplinary action. Is there any other question or comment? All those in favor, please say aye.
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 Any opposed? And that motion carries. Ms. Bradley will provide you with an order, and that will give you the date with which your fine would need to be paid. Mr. Nixdorf, there was no date with which that fine needed to be paid. So, Ms., are you wanting to make a motion to that effect, or are you willing to have Ms. Bradley?
No, you guys need to make that decision.
So, Mr. Nixdorf, would you like to make a date by, or make a motion?
If it helps, the previous one was 90 days from the order from the board. So that might be appropriate, or whatever the board thinks, or if they need more time.
And so I'll accept a motion for the time frame within that that fine would need to be paid. Any motion?
I'll make that motion to have the fine be paid within 90 days. I think that's an appropriate amount of time.
And is there a second? And that second was Ms. Booth. Any questions or comments or concerns? All those in favor, please say aye.
Aye.
Any opposed? And that motion carries. And so, Ms. Bradley will follow up with you regarding that order, and you'll receive that in the mail, I presume.
Yes, I will prepare it, and Ms. Bradford will send it to the respondent. And just so that I'm clear, that was a 90 days to pay the fine from the date of the order?
That's correct.
Thank you.
And so at this time, thank you, we're just going to take a brief 5-minute recess before we pick up with item number 14, and that's the Mia Bella Salon and Day Spa. Are those parties present?
I don't
that's
believe they're
1:30.
in Carson City yet.
Okay.
I
And
have conferred with their attorney, and I believe that they needed the hearing to be moved to 1:30, and I thought that would be fine given all the other things we had. So I think what we'll need to do is move on to other things and then come back to that
So
one.
just as a matter of formality, we'll break for 5 minutes, but we'll be coming back with an appeal of citation, Victoria's Beauty Salon. Item number 14 will resume after 1:30. Are the Alda Trindade Rodriguez with Victoria's Beauty Salon, are they present? Are those parties present? And so we'll address that when we return.
Shar says they're not present here.
This meeting of the Nevada State Board of Cosmetology is going to resume, and the time is 11 o'clock. Prior to closing for a brief break, I had asked if anyone was present for Victoria's Beauty Salon, and I did not hear any affirmative response. At this time, Mr. Nixdorf, we're going to hear item number 17, the petition to appear. Marie Quethera, license number, did I pronounce that correctly? Marie, please step up. And license number C30158. This licensee has requested to appear before the board for the concerns that she may have regarding the fees and handlings of the dates and time lapses of license renewal. Is that correct? And so if you could kindly stand and raise your right arm, Mr. Nelson will accept your name and the spelling of your name and accept your oath of truth.
Can't hear in Carson City.
Thank you. So at this time, if you would just like to provide us with maybe some chronological dates or of events that might have concerned you and your license and what we can do about it for you.
This all took place in 2008, so I'm a little foggy with certain things. I do have proof. When I took my test, and I don't know if you have the test dates for the years, but it was in the beginning of 2008, and then I waited about a month to even hear back from the state board. I passed, and then I waited that long to get my license, and I would call and find out, the status, and they said something about Florida, which I didn't understand. I'm from California, and I was just trying to get my license in Nevada, and it seems like it really drug on. And now that I look back, I think that it was because you were going through some kind of a crossover with the licenses. So they charged me $310, which they couldn't explain why they charged me the $10. I just paid it, and it was only for 1 year, not the 2 years that I thought that I was getting, which I think that was part of the crossover. I'm not sure. So that was a little confusing. And then I paid $15. I think that was for the picture. I do have all these receipts. And then I left Nevada in 2009. And I came back, and I came back this year in May, but they said that my license had expired. But before it expired, I was calling the office and leaving messages, and I wasn't getting any feedback from that. So it ended up that I had to take another test, the law test. First, it was the I can't remember. It was a national test. And I passed. And then I came back, and they made me pay $200 for another license, which, it was the crossover times. I couldn't get affirmation from the office that I was calling. I wasn't getting any correspondence from them.
Maybe I'll just interrupt you for just a quick moment. What is the status of your license right now?
Current.
Your license is current.
Correct.
And so what is it that you're seeking? Or did we fail in some way? Did our system fail in some way to meet your needs? Because you're licensed now. So what is the objective?
Well, I wasn't too clear. There was a lot. I just didn't feel that I was getting the appropriate answers I wanted to get from cosmetology office.
Okay, so from a board member's point of view, I am sorry if we did not meet your expectations in one way or another. I mean, as you know, we try to meet the expectations of hundreds of people each year, and thousands for that matter. I think there's 25,000 plus licensees. What is it that are you here just to let us know, to make sure that our systems that we have in place are adhered to, or are you asking for us to provide a rebate? What's the objective for you to let us know?
Well, I was wondering why the $310 I was charged, and she couldn't answer. I go, why are you charging me $10?
And so that was in 2008 or 9?
8.
And so, is that did we refer her to our financial department?
That's far before my time, but I think I can come up with all the figures and all that Ms. Quintero is talking about. The $200 is a reciprocity fee that she would pay. The $110 would be the test fee that would be required. So $310 total for someone to get take the law test as well as get their reciprocity fees in 2008.
And that's
it wasn't the law
310.
test
310.
in 08. It wasn't the law test in 08.
Yeah. Or whenever you paid the 310, our records indicate that you paid on 6/20/2008 through reciprocity. You paid a fee of $200 per the requirements of NRS 644-310. You failed to renew your license when it expired on 6/30/2009. And Ms. Quintero is correct. That was during a transition time frame when we went from everyone renewing at one time to the birthday renewals. And some people had shorter renewal times than others, and that was a one-time event. But with it not being renewed and there being a 4-year time frame, when that happens, according to our laws, then you no longer can renew. You now have to come in either and retest or go through reciprocity, which she has done again. Ms. Quintero was licensed in the state of California. We accepted her reciprocity through the state of California for the $200, and that's the last $200. The $15 that Ms. Quintero talked about is the pre-application fee that's required by law in order to apply for apply to test. That's one of the administrative processing fees. That's part of the process that we go through is a pre-application fee of $15. So I think that's kind of the money line of what what went on. Like I said, I've only been here since 2013. So the 2008-2009 is from our records, and that is from staff on what has happened as far as going through those time frames.
From the national test, I was when I first tested in 08, it was just confusing that she didn't know what that $10 was. Well, I mean, I'm not here to nitpick anything, but
right.
then,
And I apologize for that. If there was any confusion whatsoever, like I said, it's before my time, but if there was any confusion, hopefully we're clearing it up today with, what each one of those amounts is for.
Now that seems very clear to me, and so I appreciate that explanation. How about, is that clear for you?
And then when I did call, there was not being answered back, and I think, I would have definitely not had to retest. So that was a failure, I think, on the office part, that when I did call and leave messages and not get a response, and then saying that they saw that I was licensed, and then just recently paying the $200 to come back with a test of the law test, they said, well, we don't see your license. We don't see that you're licensed. Please. I've taken 2 tests and passed both of them. So I just want to make that clear that I am licensed, and not that someone from the office, the one that took the test score, turned around and told me that I wasn't licensed.
Yeah, our records indicate that you are currently licensed and that you did take and pass the law test, and that was part of the testing that you were required to take through anyone who comes in through reciprocity is required to take the law test. And as you stated in 2008, 2009, that was not a requirement when you first came in, but because it became a requirement after that, and because you did apply to become a licensee in this time frame, the 2013, 2014 time frame, it is a requirement of the board that every reciprocity candidate take and pass the Nevada cosmetology law test.
Okay, I guess, to the end result of this, I just want to make sure that there is no mix-up. I want to make sure that in the system, it says that I'm licensed. I absolutely don't want to go through.
Well, do you have your license? I mean, do you have a physical?
I'm working. I do have my license.
So you know your license because you have a physical copy of your license. That goes without saying, right?
I know,
but
when you
not
call
turned,
the office and then they give you that, when you
have
you're
you
not
spoken
clear
to
with,
one person in particular?
I'm sorry?
Has one person in particular said their name to you that you're speaking of?
He was the one that, I probably have her.
Oh, well, regardless of who it may have been, I'm sure that Mr. Landry will in fact speak to
Okay.
administration to ensure that this problem never happen again.
Yeah, that's
it goes
the
without
big
saying.
reason I came, because I thought, well, I'm just going to let it go and not worry about,
Well,
that I
as you
could
well
have gotten in without paying the $200. And then I thought, well, they're saying I'm not licensed. This is going to come back and bite me.
Well,
So I'm
actually, it
thinking
means
this is
a
not
great
gonna
deal
happen.
to me that you've come before the board and that you've had us assess our system of response times and making sure that this type of thing doesn't happen again. So it's very meaningful, and I do thank you very
I
much
just
for bringing
had
this.
wrong place at the wrong time. Coming into Nevada, I think it was not.
Is there any other remuneration or something that you're seeking that I just want to make sure that we cover? I appreciate that you've advised us on how to improve.
Well,
And is there anything else that you're looking for?
Because I did leave messages, and I would like, to. I know you're going to give me back my $200. Is that true?
Unfortunately, at this time, due to Nevada Revised Statute, Chapter 644, waiving that fee or reimbursing that fee is not something that we are able to do.
Could I get it in writing that I am licensed from the state board?
Well, I think you have the license.
I
That
know,
is
but
your.
that doesn't matter when people are arguing with you about things.
Okay, is there a formal procedure that we allow for licensees?
In order to resolve this matter, I will write a letter personally to Ms. Quintera stating that she is licensed and our records do show that. That would
That's
be no
all I
problem.
want.
Well, I think that sounds fair, and
Okay.
Mr. Landry has agreed to do that for you, and
Perfect.
I hope that meets your needs. Are there any other questions or comments from the boards to assist our licensee or other licensees who might experience a similar situation? Mr. Nixdorf, any questions, comments, or concerns?
No comments.
Thank you.
Okay. Thank you. Appreciate it.
That was the petition to appear. Is Genevieve Diebler here?
Yes, she
Genevieve?
is.
Thank you.
She is?
Yes.
And she's in Carson?
Yes, she is. You can come forward now.
Great. So this is a request to appeal citation CM 271, case number C14914, for an alleged violation of NRS 644.290. Ms. Diebler, will you please raise your right hand, and our court clerk, Eric Nelson, will swear you in. And Ms. Marsh, have you already been sworn in? And so he'll do the same for you.
Do you and each of you solemnly swear or affirm the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth?
I do.
I do, yes.
Yes.
And Ms. Diebler, is your name spelt correctly on the agenda as posted?
Yes.
Thank you. And Ms. Diebler, did you hear earlier when I relayed the chain of events that would happen in the this appellate procedure or the citation guide, where Ms. Bradley will present the side of the case, and that'll give you the option to ask her questions, and then the board may ask questions of the witness that's presented, and that should be Ms. Marsh, I believe, sitting next to you. Did you have any questions regarding that guide? Or
No, I understood him.
Okay. So I'll let Ms. Bradley then begin.
Thank you. Ms. Marsh, would you please state your name and spell your last name for the record?
Charlene Marsh, Marsh.
And who is your employer?
Nevada State Board of Cosmetology,
And what is your job title?
Inspector 2.
And as part of your duties as Inspector 2, did you issue the citation in this case, CM-271?
Yes, I did.
And can you tell us about that?
I was doing a routine inspection and went to Pin Up Salon. It's in Sparks, and Miss Diebler was working on a client that day but did not have her license posted.
Okay, and were you able to verify their license was current?
Yes. I did verify that and also let her know that there's a possibility for duplicate license when you're working more than one salon.
Has Ms. Diebler been provided the Exhibit 1 packet?
Giving it to her right now.
Okay, yeah, normally we'd want to wait until I've actually asked it be admitted until the board members look at it and review it. So I'm
So
going to,
maybe board members just refrain until that exhibit is actually admitted. And then Ms. Diebler would have to acknowledge that she allows us to look at that exhibit. So
yeah, so I'm going to wait till she has a copy. So have you given her that Exhibit 1 packet?
Right now, yes.
Thank you. Thank you. And Ms. Diebler, if you look through that with me, the top letter is a letter that was sent to you from the board letting you know that your matter would be on the agenda today. And then there's a signed copy of, looks like the receipt of your letter, and then your answer and consent decree, a handwritten copy of a response you had to the citation, then a copy of the citation itself, CM-271, and then a printout from the Versa system regarding your license and the citation, and then a report of the establishment. Do you see all those documents in that packet?
Yes.
And do you have any objection to the board looking at those documents in this proceeding?
No.
Okay. I'd ask that the state's Exhibit 1 be admitted.
So admitted.
Okay, so going back to Ms. Marsh, it looks like she might be.
I'm back.
Thank you. So I think you just testified that you saw Ms. Diebler working on a client and her license was not posted.
Yes.
And you verified that it was current.
Yes, I did.
And so then you issued the citation?
Yes, I did.
And is there anything else that you'd like to tell us about the inspection or the citation?
No.
Thank you. I have no further questions for Ms. Marsh.
Thank you. Do any board members have questions of the inspector? Oh, Ms. Diebler, actually, you're first. Pardon me. Ms. Diebler, did you have some questions of Ms. Marsh?
No.
None?
None, no. She did her job that
Okay.
day. So.
Thank you. And board members, any board members with questions of Ms. Marsh? And there being none, Ms. Diebler, now is an opportunity for you to talk about your side of the story. Oh, do you have cross-exam, I guess?
No.
Oh, no, I don't have any further witnesses, so I would rest.
Oh, okay. Thank you. I'm sorry for that confusion. Evidently, Ms. Bradley had the opportunity to call additional people, and I've overlooked that. So, Ms. Diebler, now is your opportunity. Sorry for interrupting you.
Oh, no, that's fine. Thank you for hearing me out. I have been in the business for a very long time, and when the economy took a plummet, I did end up working in 2 different salons. And at that time, when I started doing that, we were not able to get duplicate licenses, which in return, I just took them back and forth, which is fine, no biggie. However, sometimes accidents happen. It was an accident, and I take full responsibility for that. However, I feel like a $200 fine for a first-time offense for somebody that's never done anything wrong is just very expensive when you're a single mom raising kids and doing the right thing. And that is why I'm here today. Ms. Marsh did her job. I take responsibility, but I just feel that $200 is steep. on this account.
Thank you. Thank you. Ms. Bradley, did you have questions of Ms. Diebler?
I don't, thank you.
And do the board members have any questions of Ms. Diebler? So by your own admission, you did fail to have your license properly displayed?
I did. I thought I had grabbed it and it had fallen out of my packet that I carry back and forth with me with my license in it. It had fallen out at my other shop and it was on my other station. So, yes, I forgot it. Well, it slipped out, so.
Have you, since the citation was issued, applied for or received a duplicate so that you don't have to carry it back and forth now?
That I have not yet. I have kids at home and I work full-time, almost 7 days a week, and then with football, but that's something now that I'm aware that I can get them. I will do that as soon as, well, football season's over, so I'll do that soon.
Thank you. Okay, so did you, I guess Ms. Bradley has the opportunity to have closing statements first?
I would just submit that I believe that the testimony does support that the violation did occur and ask that you uphold the citation.
And then Ms. Diebler, you have the opportunity for any final comments or closing statements?
The only thing is that I'm asking is that, yes, I take responsibility for it. However, I'm asking for a reduction in the $200 fine. And I'll be applying for my duplicate license.
Board members, any comments or questions or concerns?
I have a comment. It's
Mr. Nixdorf. Yes.
In the Law and Administrative Code book that everyone should have a copy of if you're a licensed cosmetologist, it clearly states the fine structure for disciplinary actions at $200. And thus, I would say that that Ms. Diebler would be or should have been aware that that's a $200 fine that goes with that. And being that that's knowing, and I didn't see her here months and years ago when these come out that says, oh my, this isn't good. If I ever get caught, that's not going to be happening. I don't like that fee structure, and it is what it is. And it's clear, and everybody can see it at any time.
I will remind the board as well, we have in the past, I remember a case specifically where we upheld the violation but did not fine, with the stipulation that if another violation occurred, then the second tier of fining would incur. So I don't know if that's a way to solve the problem.
Well,
but it's a potential idea.
Did I hear you offering a motion, Mr. Hoffman?
I did, in fact, not offer a motion. I was merely discussing amongst the board, as I thought we would.
Would anyone like to suggest a motion to the effect of? Please, Ms. Booth.
Being a single mom, I understand a hardship. I really do. Is there a way for someone to make their payments in 2 months or 3 months so that they don't have to just come down and make it all at one time? Is that a possibility?
You could structure a motion that included a time frame for the payment of a fine, for sure. Were you offering a motion, Ms. Booth?
I will offer a motion. I'd like to uphold the fine. I would like to give her 4 months. She could pay $50 a month for that fine, because I just see starting a bad trend. If you do for one, you have to do for somebody else. And I think that by giving her the 4 months, that would take away that hardship.
So there's a motion on the table. Is there a second?
I'll second.
Thank you, Mr. Hoffman. There's a motion on the table with a second. Any questions, comments, or discussion? Mr. Nixdorf, you're comfortable with hearing what that motion was?
I'm comfortable with the motion. I'm just got a question for Mr. Landry in that. What's the current amount of time that she has to pay? Is that prior to renewing her next license, or is there a time frame that we expect her payment currently?
It must be paid prior to her next renewal. And we certainly would encourage anyone to pay as soon as possible. But the legal time frame would be that all fines and citations would have to be paid prior to the renewal of her next licensure.
And is that within the 4 months, Mr. Landry, that the motion on the table is highlighting?
I'm not familiar with her expiration date of her license. I apologize.
Ms. Diebler,
do you?
Yeah, when is the expiration date for your license? When do you need to renew it by?
September. I'll have it paid by then. It's not really.
I'm sorry, when is it due? When is the renewal date of your license?
September.
Oh, next year. Oh. So again, the renewal date falls well outside the 4-month cycle that Ms. Booth's motion indicated, that the upholding of the fine, but with an option of roughly 120 days, if I'm.
I'd like to amend my motion to remove that because I wasn't aware that she had until her next renewal date. So she could pay it at $25 a month if she wanted that way.
Well, is that accurate? There's no interest or anything assessed?
No.
And is that paperwork? Is there too much paperwork to try to monitor this trickling effect of a fine?
No, we simply, any transaction that comes in through the board office is just, put into our accounting system, and we track it that way. But it's not an undue hardship on the board or board staff.
And Mr. Hoffman, Ms. Booth amended her motion to just uphold the fine and then have the fine
I'll
paid
amend my
prior to
second.
renewal. Okay. And so, Mr. Nixdorf, does that alleviate any questions or concerns you may have had about when that fine is to be paid?
Yes.
Normally, just so you're all aware, normally we actually handle this in 2 parts. So normally you vote to uphold the citation or not, meaning the violation occurred or not, and then you normally vote separately on the assessed amount, whether you're going to keep it the same or not. Now, you don't have to always do that, but I just wanted to clarify because I think normally we do this in 2 steps when we do the citation. So I just didn't know if anyone was confused because at first I was. So
I was just under the impression that she admitted guilt and so that was established. If that's not established, then do you want me to?
You'd still have to vote on it because there needs to be a finding of the board that the citation itself should be upheld or not, and that the violation did or did not occur, which is what that part is.
And I think she just combined it.
Yeah,
she said
it's fine. I just want to make sure everyone was clear because
okay.
Normally we haven't done it this way, and so I didn't know if that was contributing to some of this.
Do you prefer that?
Normally, it would be done as 2 separate motions, but she did combine it, so I was going to let it go.
Are you comfortable still combining
I'm still comfortable, yeah.
Okay, and you're comfortable with your motion combining the upholding and then the fine? Okay. And so that meets, thank you, Ms. Bradley, for that point of clarification, and we'll try to make those motions appropriate in the future. Any other final comments, questions, or concerns? All those in favor, please say aye.
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 Any opposed? Ms. Diebler, that motion carries, and our Ms. Bradley, the Deputy Attorney General, will follow up with you with a written order, and that'll explain your obligations to have that fine paid prior to license renewal.
All right, thank you.
Thank you. Oh, right. And so we had done some shuffling prior to, is anyone represented Mia Bella Salon, item number 14? That's our remaining.
No, that's at 1:30. We should be doing Victoria's Beauty Salon.
Oh, pardon me. I'm looking at the wrong one. Alda Trindade Rodriguez, the appeal of citation CM 248, case C14 827. Is anyone from Victoria's Beauty Salon present?
She's not here, and we have not heard from her that I'm aware of.
And do you have any evidence of proper posting or certificate of service?
That would be Monica.
I think Ms. Bradford has that information.
Okay. And so it sounds like Ms. Bradley, you'd like to continue?
Sure. So I don't know if Ms.
That's
Bradford
actually in
has
their
been.
board packet.
I understand. I don't know if Ms. Bradford has been sworn or not.
No. Ms. Bradford, will you please stand and take an oath of truthfulness? Yes, an oath of truthfulness.
I do. And before we start, I have an Exhibit 1 that I believe has been pre-marked that I would like to submit to the board, and I ask that it be admitted.
So admitted.
Oh, well, yes, thank you. It is. Thank you. Thank you.
Ms. Bradford, would you please state your name and spell your last name for the record?
Monica Bradford, Bradford.
And who is your employer?
The Nevada State Board of Cosmetology.
What is your job title?
Executive Assistant.
And as part of your duties as executive assistant, did you send a letter to Victoria's Beauty Salon regarding today's citation appeal?
Yes, I did.
And is that letter the first 2 pages in the packet that's marked Exhibit 1 for this case?
This is the one that I called the wild animal.
It is.
And if we go to the 3rd page of that mailing, or of that packet, excuse me, is that where we have a USPS tracking confirmation?
Yes, it is.
And what does it say for the tracking of this letter?
Delivered on June 25th, 2014.
And if we go back to the front page of the letter, there's an address there, 1434B Victorian Avenue, Sparks, Nevada, 89431. Is that the address on file for Victoria's Beauty Salon in the board's records?
It is, as I know it.
Based on Ms. Bradford's testimony, I would ask that the board find that the respondent, Victoria's Beauty Salon, Alda Trindade Rodriguez, has been given proper legal notice of today's citation appeal, and that we can continue the matter in her absence.
Ms. Bradley, isn't this also the second time that we're hearing this? Didn't this person also not show at our last meeting?
Ms. Bradley?
Yeah, I believe that, I'm going to look in my file here, but I've got
I do believe the board does have the second notice that I submitted to them, and I do have proof of that also. And that was submitted on August the 13th, which asked the respondent to come into the November 3rd, 2014 meeting. And they also have verification of delivery of that.
Yeah, I'd like to make that part of the record.
Oh, I would too, and I apologize. I don't think my file's updated. I'm not sure why, but
the board does have that.
And does she still have the wild animal in the salon?
I'm out on that one.
You're referring to it like it's a tiger, isn't it a parrot?
I'm just saying.
Wild animal. Gotcha.
So just for the record, Ms. Bradford, when was the second letter, the August letter sent, notifying her of the November 3rd meeting date?
On August the 13th, after she had requested to extend her appearance based on some health issues at our August meeting. And so on August the 13th, since the board had approved to go ahead and give her a continuance, I went ahead and filed another notice to ask her to please appear on the November 3rd board meeting for today. And I have verification of that delivery also.
Okay, and what was that date, just for the record?
The date on that one was August the 15th, that it was delivered to the 1434 Victorian address, and it was signed by Victoria Salon. I don't know, I can't make out the person, but I do have verification.
Okay. And has the board office received any communication from Ms. Rodriguez or the salon regarding today's appeal date?
We have it in Las Vegas. You might want to ask Charlene, since she's actually in the upper Nevada area.
Ms. Marsh, can you confirm whether or not there's been a communication from the licensee in this case to the office there in Reno?
We've not had any calls or communication from Victoria Salon.
Thank you. So based on Ms. Bradford and Ms. Marsh's testimony, I would ask that the board find that the respondent has been given proper legal notice of today's citation appeal so that we can continue this matter in the person's absence.
I make a motion that we find that the respondent was duly informed of this proceeding today.
Is there a second, please?
I'll second.
Microphone.
Is there any question or
I'll second.
Thank you, Ms. Booth. Is there any question or comment or discussion? All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
Any opposed? And that motion carries.
And then based on NRS 622A.350, which states the failure to appear, that in that situation, the board may deem that the charging document is true. I would ask that, based on the failure to appear today, that the board uphold the citation in this case and also the fine, which was $200. So I'd ask that both the citation and the fine be upheld.
So at this time, I'd like to ask a board member to divide that into two parts. The first is to assess whether the violation is in fact proven or is in fact a violation.
I'll make a motion that it has been proven that there is a violation.
And to be clear, that's NRS 644.472.
Correct.
And I'll second.
And is there any question or comment or discussion? All those in favor, please say aye.
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 Any opposed? And that motion carries. Is there a motion for disciplinary action? To uphold the fine?
I'll make a motion to uphold the fine.
I'll second.
And so there's a motion and a second. Is there any question or discussion? I do have some. I do too, Mr. Nixdorf, and this is the second time that we're hearing this matter, and I would like to see costs associated to this. No, you can't do that.
Well, you can't do it. It's not been noticed for that. The person hasn't been noticed that. And the previous time they indicated they were ill, and so you're going to, I mean, no.
Penalizing
It's
somebody
either,
for being sick?
Yeah, you
well,
can't
it's either
punish him for...
$200 or nothing.
Mr. Nixdorf, any comments or questions?
Mine was kind of along the same line as yours.
So you kind of hear that what the response was by Ms. Bradley about it?
Correct.
Yes, I did too. Any other questions or comments or discussion? There is a motion on the table to uphold the fine. All those in favor, please say aye.
Aye.
Aye. Any opposed?
Aye.
And that is unanimous, so that motion carries. And I believe that completes the complaint portion except for the item number 14, which we hear at 1:30?
Yes, it does. So I don't know if the board wants to go to lunch at this time and then come back at 1 o'clock, or if we should continue to hear other matters.
Mr. Vice President, Mr. Nixdorf, at this time there's an opportunity for you to take back control of the meeting, and if you so choose to do so, you're welcome to adjourn for a lunch hour, or you're welcome to pick up with item number 19, because item number 18 was moved to after 20. So if you prefer to see 19 discussed after lunch, we could do that.
Thank you, Mr. Leader. I would like to finish off, and I don't think this is going to be a very long discussion, and I think that we can do this before 12 o'clock. So let's take up number 19 and then break for lunch after that.
And so are you then going to conduct the rest of this meeting?
Yes.
Thank you.
Thank you very much. You did a great job. Okay, so item number 19. All right, so this item is a discussion of the use of Credo blades and cheese graters in the practice of nail technology in the state of Nevada. We have information from staff along with Board Member Joanne Tran. Board Member Tran will present her information first, followed by the Executive Director Landry's findings, and from staff. Ms. Tran, please go ahead.
Hi there. Well, we stopped using the Credo blade, and now everyone's using the cheese grater, and some are purchased in the grocery store or whatever. And I feel that that's just very dangerous at this time to see this in all the salons, because that's what they're using right now. And they have it online too, but I see a lot of clients do come in and do complain about other salons using it on their foot, and then it's too harsh, and they do complain it does hurt. And I have seen clients that come in with, their feet being really red and raw because of these cheese graters. So I wanted to, maybe look into it a little bit more. When the inspectors go out, maybe just check on them. We can try to, maybe see what they're using, because they are starting to sell it in this, the beauty supply also too. So I don't know what everybody thinks about that.
Mr. Landry, correct me if I'm wrong, Credo blades can be sold as a retail item in salons, though we don't allow them to be used in the salons.
That is correct. We don't have authority or jurisdiction over the retail sales of products, whether it be in a salon or in a retail establishment separate from a salon. But that is a correct statement. They can be sold, but they cannot be used. The one difficulty that we face, as Ms. Tran has pointed out in her testimony, we see that they're there. We can actually see callus shavings on the Credo blade or on the cheese graters, and there's nothing that we can do until we see them in use, because that's the way the current law is written. We have to see the item in use in order to cite them and find them. The board has pushed forward through the law subcommittee, through the workshops, and now through public hearing, and finally to our bill sponsor, where that will change in the future. If we can get the legislature to go along with us, then we will have a list of banned devices. And when that list comes up, I would expect that we would have a discussion and detailed listing of cheese graters and other similar devices that may be banned from the salons at that point.
So you're saying that an item that we've deemed not usable in the performance of pedicures, even sitting next to a chair with biological material on it, unless it's actually in somebody's hand, we can't write a citation.
That's the way we've done it to this point. It becomes very difficult.
Okay.
There's certainly deniability by saying that was someone else's, because in the pedicure area, a lot of times they're shared appliances. So it was the last pedicure, last nail tech that did this, not me. That's the kind of difficulty we run into. We could certainly issue a citation and try and prove it.
Yeah. You could cite the salon itself. I mean, Well, the point is that the whole burden of proof is just more likely than not. So it's a preponderance of the evidence, so 49% to 51%. So if you see something that's banned or not to be used and it has biological material on it, clearly it's being used. And so I think you can prove that at least to a preponderance. The issue, of course, is going to be who used it. It can be an assumption, and that's your job as an investigator. A preponderance of the evidence is the burden in this hearing. So it's more likely than not that someone is using it. Now, the problem you're going to have is, of course, who is using it.
I think that's it has been an ongoing problem. It is not a new problem. From the time when Credo blades were first banned from being able to be used. The true solution is a change in the law, and we're getting to that. But the problem we have today is, even though, as Ms. Bradley said, we could assume from the preponderance of evidence that it has been used. It's the proof of who used it is going to be difficult, and we don't have, we certainly don't have the skill sets to do fingerprint analysis and DNA. That's.
I was going to say, are we fingerprinting Credo blades now so we can establish guilt?
Yeah, I think a much easier solution to this is we will continue to monitor it. We will continue, as Ms. Tran said, to inform the nail tech salons that this is not an acceptable practice, and that that we do have laws coming down that we're proposing that will make it a violation. And I can assure you, once that law becomes effective or enacted, we will have a education system for those that are using it with a warning system. And after that, every device that is banned that we see, we will be citing. There will be no exceptions on that.
Mr. Landry, isn't there an opportunity for, rather than having the inspectors issue citations, just have them issue warnings because there is an appearance of tools being used that may or may not be approved for use? And so there's not necessarily a citation that's given, but just that it does appear that your salon may be doing something inappropriate. And this is how we're going to address it in the initial stages.
Typically, the inspectors do that whenever they see something that we can't cite for, but that is not appropriate or not, is not something that exhibits safe sanitary or infection control and prevention practices, or that would cause harm or damage to the public. We do give warnings. We do give, we talk to them and try and educate them about why that's the case. Unfortunately, without the teeth of a citation and the ability to completely ban a device from a salon, that's a difficult thing for us to do right now. But we do not stop giving warnings. We do not quit letting people know and letting the salon owners as well as the licensees know that it is not good practice. It is unsanitary and unsafe, even though we can't particularly cite for it right now. But we do warnings, and our in inspection our goal is always compliance. It's not all about the citation. So there are a lot of times when we will talk to salon owners, make suggestions, and tell them what they should be doing, because we do want compliance with the law.
I'd like to hear from Annie, please. Your perspective.
Okay, my perspective on the cheese grater, I see that it is a blade. Actually, I view it a little bit more dangerous than the Credo blade because it goes into deeper areas, grooves into the heel. Whereas with the Credo blade, it was like a straight across the top. But it still is a metal blade. It's just configured a little differently. So I would like the board to put that in the same category as a Credo blade. That's my opinion.
Thank you, Annie.
I have something I'd like to ask, because I know we're talking about cheese graters right now, but I know I can go in the store and get something called a petty egg, and that has it looks like a little cheese grater on the back side of it, and then it has a little sander. So if we ban just a cheese grater, I think we should have a discussion on things that are sold over the counter that aren't called a cheese grater, because that would fall in, I think, to the same category.
Yeah, I agree with Ms. Booth that one of the things we need to do is when we start banning things and we start restricting the use of certain items, we do need to be very specific on what that is. One general category is that any item not intended for use in the beauty industry would be banned if it has those type blades. So a true cheese grater, because we are seeing that in the salons, not a petty egg, not something that has like a heel rasp or whatever. It's actually a microplane or OXO cheese grater labeled as a cheese grater, and it's meant to grate cheese and not to be used on a human being. So those type things we can ban a large variety of those When it comes down to the individual ones, I agree with Ms. Booth. We need to really, purchase some of them, bring them in, take a look at them, analyze, see how how our laws reflect on the use or both either the safe or unsafe use of that, and bring those before the board. I think that's going to be a continuing effort as we go forward, as having devices brought before the board so you can actually see what we're talking about, what we're finding in the salons.
I have a question about the underlying reason why we don't want to have a Credo blade or a cheese grater being used. What's the underlying reason there?
The ability to spread blood pathogens by rupturing the skin down to the dermis level and allowing a lot of blood to come out. I mean, the Credo blade was originally taken away because of that. You can literally shave right into the skin.
Yeah,
I imagine a cheese grater would do the same thing.
I could get my I could get my fingernails clipped and have them clip my cuticle and draw blood as well.
There has been a situation with the board a few years ago where which prompted the discussion on eliminating the use of the Credo blade. And I think it was about 6 years ago. Somebody had, a licensee had shaved off a birthmark with the Credo blade on a toe. And I mean, I could go back to my minutes because I keep pretty good, accurate minutes and provide that to you, that testimony in those minutes. And that prompted the regulatory review for the use of Credo blades. So that was probably in 2006, 2007.
Thank you. And Mr. Landry, I know you're a big proponent of of checking what other boards are doing across the states. What have you found there? Is there anybody that lets this stuff get used?
That I'm aware of that allows the use of Credo blade. It's pretty much been universally banned among all cosmetology boards across the United States. I can't think of anyone that I'm aware of. Certainly no states no executive directors that I've spoken with, because we talk about that pretty often as far as banned devices and all. And Credo blades are pretty universally banned. I'd like for Annie to maybe read from our regulations exactly why what this violates.
Okay, in NAC 644368, number E, it says the removal of callus using an instrument, tool, or other device that has sharp edge, blade, or point. I would think that would be a definition that would fit the cheese grater.
Absolutely fits the cheese grater as well as the Credo blade.
And we already have that in our regulations, so I think we could go forward.
Well, and I think Ms. Curtis.
Under prohibited evasive
procedures. And I think, calling something a lemon zester or a citrus zester, I mean, that's going to also fall into the same category as a cheese grater. So, I mean, I think you can call things a lot of names, but I think Ms. Curtis read to you exactly the function of those variety of tools.
I concur.
So you're saying we could cite them now? So you're saying we could cite them now? For the cheese grater I'm talking about.
We don't have any ability in the finding system to cite. With the new regulations that we're going to be proposing, we're going to put the language in that would give us that ability. But right now, it's no language to say that we can cite them. We can ask them to remove it, but they don't have to. We have no power. We have no teeth.
You just read us that said that they couldn't have.
This is using it. We have to see them using it.
Okay. So you only can do it if you saw them using a cheese grater or a Credo blade, then you could cite them.
We could actually write a complaint against them if they were using it. That's what we would have to do.
Okay.
We don't have the ability to cite with a citation, but we could always do a complaint and bring them before the board.
So are you guys seeing when you're going into a salon, are the inspectors seeing that the people are hiding these cheese graters, or are
they're visible, but we don't see them using them.
But they're smart enough not to use them in front of you.
So as long as they're not touching it while it's happening, they're not violating the law. But as Ms. Bradley
with it in the salon, we have no teeth.
But as
no
Ms.
power.
Bradley stated, if we were to issue a citation for the salon and bring them before the board, it's the preponderance of evidence to figure out, right? Isn't that what you were saying or stating?
I mean, yeah, the preponderance of evidence is more likely than not it's being done. So I don't know. I mean, if you look at this, no salon owner can violate any regulation of yours. So if they're using these procedures in the salon,
Opted for using.
well, it doesn't matter. I mean, if you see skin or something on it, I think you know it's being used there. So I think it may be possible. I don't know that it'd be possible in every case, but if you see something in the salon that clearly has signs of use and using that item in the salon is prohibited, I think you can go after the salon owner. I don't know. I saw in the back shaking heads about that, but I don't know that it says in here because a salon owner cannot allow anything that violates the law to happen in their salon.
I also wanted to point out, too, that if they are called before the board and are sitting here, they're under oath. So if they choose to lie on public testimony, I think that is a bigger issue than even using the unlikely tool on.
So you're saying that whenever somebody swears, they're always telling the truth? Is that what you're?
I want to believe that, Mr. Hoffman.
I'm sure that you do, but just so we're clear.
This is another discussion another day.
I do understand that. I think it's hard to tell which individual licensee, for example, which nail tech is using something. But if you see something with signs of use that's unlawful in the salon, I mean, the same would be true with used single-use items behind workstations. And I know you see that all the time. You know, they're used and they're there. What's the purpose? Well, the purpose is for use. They're in little cups behind the stations, and you've cited salon owners for that. So I think it's a similar analysis, unless I'm missing something that says, because you have to look elsewhere where it talks about the regulations for salon owners.
Yeah, I think the main difference, Ms. Bradley, is that when they use a single-use item, it's a sanitation violation, which we have a clear citation authority. But I concur with your point that we could bring them up on a complaint hearing, but it would be for either unfair business practice or a violation of one of the sections of the law.
Yeah, because that's what, I mean, if you look at grounds for disciplinary action is NRS 644-430. And 1A is the failure of an owner of an establishment to comply with the requirements of this chapter or the regulations adopted by the board. So if you see a cheese grater or a Credo blade with signs of use,
or a petty egg or anything that they
it's
used.
being used in that salon. And so that would, yeah, you can't cite for it, but you can bring them before the board in a complaint hearing on that issue. And perhaps it would be important, especially if you see other violations in that salon, perhaps a citation wouldn't be the best thing. Bring them before on all of it, because maybe that's a dangerous place to go.
Sarah, what would happen if they don't show up? What would be our recourse?
It's the same as any other time someone doesn't show up. So if a complaint's filed, they get notice of the complaint, and if they don't show up, there's regulations that say that you can find that everything that's in the complaint is true. And when I say complaint, I mean the complaint that our office drafts that has factual allegations and violations of law. And so that's true. If they don't show up, they don't oppose it. Another option would be
no fine attached. So
why wouldn't you find an active salon owner?
Because
you have a hearing. I mean, it's just like all the other cases we do. So a complaint notice of hearing is drafted. They don't show up. So then I make an offer of proof that we've given them legal notice of the hearing. And then I say, here's the law, NRS 622A.350, that says if they don't show up, you can find everything in the complaint as true. And then once you find it true, then we talk about fines. And so the fine per violation is up to $2,000 per item. And so it's going to depend on what's alleged and how many things there are. And then we can get costs. So it's just like any other case that you have. They're an active owner of a salon. Now, it could get to the point.
Doesn't that also include suspension of license, revocation
Oh, absolutely.
of license.
License suspension, revocation, et cetera. It doesn't have to be a fine. And that's what I was going to say. If it's a pattern or if it's really serious or if this is maybe the second time we've had a complaint, you could revoke the license for failing to come. You could suspend the license for failing to come. You could do, worse things than just money. A lot of times we do that, but it can be anything.
Well, at this time,
I have a question.
Just one moment. At this time,
Mr. Nixdorf, Ms. Curtis was just trying to make a point. If you can hold on just a second.
Sure.
Okay, I have a question. The way the conversation appears to be going is that if we go out to do complaints against the Credo Blade, we're going to attach that to the owner. There's also independent contractors. There's people in the salon that are working under their own jurisdiction. So how are we, if no one admits that they are the person that it belongs to, how are we going to differentiate and write that complaint against someone?
Well,
unless you're making a statement that it's going to be the responsibility of the salon owner for having Credo Blades in there. Because this regulation does not say that.
They can come here and they can make that argument, but the law is that a salon owner has the obligation to make sure the law's followed.
That's who we're going to be writing the complaint against.
Well, that's the one that's the easiest because you don't have to see them using it. If you see signs of use in an instrument that's not to be used, then you know it's being used there. They have a responsibility to make sure it's not. Now, it'd be better if you saw someone using it because then you can cite them as well, but or bring them before the board in a complaint.
What you're also saying is if we do see someone, this is what I'm understanding, and I want to be clear. If we see someone using it, then we're going to bring that, because we don't have citing power, we're going to bring that person before the board as well as the owner?
Sure, absolutely.
Okay, fine.
Yeah, you can do it under the law. It's just the question of whether or not you want to in every situation. I know there's a salon that I go to that's independent contractors, and I have concerns sometimes about things being done there. And I in my view, it may be because they're independent contractors, they're not overseen as carefully, but the owner of the salon still has that obligation. That's what the law says.
So my comment on this is that we have a law that we hope, and I have a fair amount of faith, will pass, which would be the ability to ban things. And I think that would be a far more prudent thing to wait for. It's not that far away, relatively speaking, before we go and start bringing people up in front of us with complaints against the salon and so on and so forth. So it's been going on for a while. We mitigate as much as we can by warning and consulting with them, and I think that we should just wait until after the legislature does approve or not approve the ability to ban a device before we make any kind of decision as to what the inspection department should be doing. Anyway, that's my comment on that subject.
Mr. Nixdorf.
I'd like to say I really agree with what Perry's saying. I think that we really need to let it become law and then deal with it, because I think we'd just be opening up a can of worm and a long discussion about stuff that we really couldn't sink our teeth in. So I just want to say I agree with Perry's comment.
I actually slightly disagree, Ms. Booth and Mr. Nixdorf, in that in our obligation and duty and responsibility to protect the public, we can't wait sometimes for laws to say that something is banned. We have the appearance that the public is in danger, because we've set a policy that those tools are not to be used. And now we're seeing a repeated pattern of possible use. And in order to properly protect the public, we do need to implement policies prior to our legislature enacting law.
I just want to be clarified, though, that it's already against the law in NAC 644368, as Ms. Curtis pointed out previously, subsection 1E, to remove a callus using a device that has a sharp edge, blade, or point. So I just want to make sure we're clear here. I would never tell you to do something that you don't already have the power to do. So it already is against the law to use anything that has a sharp edge, blade, or point in removing a callus, period. It's just not against the law to have it in the salon. And so the banning is going to say you can't even have those things in the salon. And that would make it easier for staff, because then they don't have to see it being used and they don't have to see signs of use. They just see it there, and that's a no-no, right? So, but I just want to make sure it's clear for everyone that it's already against the law to have those things and use them. Well, maybe not have them, but it's already against the law to use them on people, period. And so we're just trying to clarify the law and saying, well, not only is it against the law to use it on people, it's against the law to have it in the salon as well. And that would just make it easier for staff. But I mean, going forward, I think if they see signs of use of one, they can, and I would say signs of use could be in the drawer by the workstation, because again, what's the purpose of it being in the drawer by the workstation if it's not being used? Now, if it's in the front in the counter for sale with the buffers and the things they sell at the front of the salon, that might be a different situation. But if you see it in a drawer by a workstation, I mean, what's
in a quats?
Well, what's the conclusion you draw? I mean, the conclusion you draw is that it's being used. That's why it's there.
So then perhaps a motion that directs the inspection staff as to what the State Board would like to see happen as we get closer to the law changing?
Well, I think we've answered that. I think that the inspection staff should be issuing warnings and issuing the warning to the establishment with the possibility of having the establishment owner come before the board to either affirm or deny that those tools are being used within their establishment, and to offer an explanation if they're not there for use. What's the intended function? To be at a workstation.
So if I'm getting
to be completely clear, I'd like to have whatever the final board action is in the form of a motion and a vote, so that we get, so that staff and myself will know exactly the intent of the board.
Right. So, Mr. Leader, if I get you right, what you'd like to do is have the staff direct them to step up their enforcement on this particular one issue through the use of issuing more citations, not citations, but warnings, initially to build an awareness, followed by perhaps a more stringent citation policy. Is that what I hear you saying?
I think that that's a portion of what I'm saying. I mean, obviously, I'm going to defer commentary to Ms. Tran, the nail technologist board member. I mean, she's brought this issue before the board. I certainly am going to follow her lead. If she feels that there can be a greater perception of public safety, and certainly a much more rigorous attention to public health and safety with the use of issuing warnings or possibly bringing establishment owners before the board, or any other action that Ms. Tran feels is the most effective measure to, to deal with this egregious behavior. I'm kind of very fully in support of her recommendations.
Ms. Tran, do you have any kind of recommendation for the staff?
Well, I do recommend that we try to ban the use, which is the same as the Credo blade, somehow. But in the state of California, their law, when an inspector walks into a nail salon and there is a blade of any sort that's banned, they are cited. Doesn't matter if you're using it or not. If it's in the salon, it is being cited. So, I'd like to see something like that, maybe change here. What is the blade doing in the salon? I mean, if you're not using it. And we want to prevent, an accident happening, because they're not using the Credo blade, but they're using something else now. So we want to wait for an accident to happen, somebody gets hurt, to get it into law. So I do like to see, this type of instrument not being used on the clients.
All right. So I have a proposal that might work for this. See what you guys think. Perhaps we can instruct the staff to step up the awareness and build an awareness of the that they shouldn't be having those, that they shouldn't be used, and just talk about it a little bit more, with the addition of informing them that there will be a law coming down, or there's a bill draft that says that those devices will be banned, and that they should consider not using them or not having them in their salon, and start with building an awareness, and before we come down heavy-handed and start issuing a bunch of citations. I think that everybody should have a bit of a warning system in place. And then once we have that law in place, then we can clearly cite, and it would be much easier to eliminate those devices. But I think we can start by increasing the awareness. Mr. Landry, do you have any comments on the ability to do that?
No, I think I'm pretty well understand what you're getting at and what you'd like to hear. The only thing I would reserve is that you don't blunt our efforts to bring a complaint hearing if we see something egregious, because that's part of the law and part of the regulations that we enforce. If we see something egregious, we will bring a complaint hearing before the board. And so I agree with the awareness part, and we are certainly, like I said previously in testimony, that we look for compliance, and that is what we're trying to get to. If we don't see that there's compliance, we do have the mechanism of using a complaint hearing for the overly egregious violators.
Clearly,
it's already against the law.
Right.
It's already against the law.
Certainly,
so
we know
we're not waiting for the banning, but just strictly, it's already against the law, and law needs to be upheld. Just like
the law is being upheld right now. We just can't do it unless we see it. So really, what we're talking about is a lot of gray area where we can't apply the law, even though we have the law. And that's really, if we just increase people's awareness that that's definitely not okay, and that's where our focus is, perhaps we can get more voluntary compliance to that and fewer blades out there until such a time as when we can actually ban them. I know we know it's against the law.
I agree with you to a point, but I do think that when the inspectors are talking to them about it, they should state that according to 644-430, they shouldn't be using these implements currently, and then they will be banned, and then it's going to become a precipitous.
Correct. It's all about building an awareness and making people much more aware that that's just definitely not okay, and we're going to be enforcing that, and we're going to be looking at that closer, and with the eventual end game being that none of those items will be available in a salon for use, period.
Can I say one last thing here as I'm listening to all this? I'm out there in the public. I know they're using these things. I mean, I see them everywhere, but they're not using a metal one. There's another type out there that they're using. It's like a plastic looking, but it's like what some of these knives are made out of now. What do you call it?
Ceramic?
Yeah, they're like ceramic graters. So I think, what would be your definition? To me, I think once we get the law changed, this is going to eliminate the whole problem. But I could see somebody in here debating.
Well, it's pretty clear. It says sharp.
But in whose opinion? I mean, it's
ceramic is more sharp. A lot of times.
I don't know, but I'm just saying that's what I'm seeing a lot in the salons are ceramic, because I think the metal ones probably rusted too fast on them. So I don't know, but they're out there. They're using them. I agree. And for the safety of the public, absolutely should be removed, but it needs to be very, very clear. And I think the education piece that Perry brought up again would be great, is if they could get out there and start educating them that law is going to come down hard on them really soon.
All right. So
Mr. President, would you like me to make a motion then to that effect, or do we need a motion on this discussion? So, Mr.
I think it would be best if you did a motion to direct the staff so that they have a clear idea where we want to take what our point of view is, and that they can work with that.
Well, it sounded like we had three issues. The first one being protecting the public, obviously. The second being that we do want to create an awareness or educational campaign. And then the third issue is that there will be ultimate legislation which bans the use of certain implements. And so I would just make my motion to instruct Mr. Landry and staff to continue your best efforts
to eliminate this as a problem. You've heard the discussion. You've heard the laws that were quoted. There is no intention of any of the board members to blunt the efforts that you've referred to. And in fact, if anything, I think we've kind of given you some guidance that we're willing to step up, listening to folks come before us to try to defend the possible use of those implements. And so my motion would just be to look at your day-to-day business activities and include this as a measure to ensure that the customers of cosmetological establishments receive the best care. I mean, I don't know how else to word a motion to that effect other than you're the best person to know how to structure your inspection staff to minimize this as a problem.
I'll second that.
Thank you, Ms. Benaldi. Any further discussion? All right, I'll call for a vote. All in favor, say aye. Aye.
Aye.
Aye.
Anyone opposed? No one opposed. Motion carries. All right, so we're going to adjourn for lunch now. 1 hour, is that good? So we'll adjourn we'll be back in session at 1:15.
Probably shoot for 1:30.
An hour and 15.
An hour and 15? Sure, 1:30? I'm okay with that. All right, so we're adjourning now at 12:16, it looks like, and we'll be back in session at 1:30.
Perry, we're waiting on just a couple people to come back. Not quite ready yet.
No worries. I can see that you're not all there, so.
Most people can see that when they see me.
We're just creating a room.
All right, Mr. Vice President, I believe we're ready to kick off if you'd like to. Oh, wait, sorry. Mr. Nelson is, give us just a moment, Perry. Sorry. Oh, and Miss Booth as well.
Yeah, and Mr. Leader will probably want to be sitting in that center seat there.
Because we have another hearing coming up.
That's correct.
Mr. Nixdorf?
Yes.
I can see that the attorney representing the Mia Bella Salon is present, but is the licensee going to be present also, or?
The licensee is there.
Oh, okay. So you can come forward if you'd like. We're still waiting for one last board member. We'll maybe just be a couple more minutes. And then did you have any other witnesses that you also wanted to bring up? Anybody who's going to? That's okay.
You'd want to ask Mr. Taylor whatever she wants to do in Carson City.
Okay.
Yes.
Mr. Taylor, is there anyone besides you and your client that would like to testify today?
Well, I assume that the inspector will be testifying, and I may have some questions for her, but no other independent third parties.
Okay. And if you'd like, why don't we bring the meeting in session, take care of some business, and give Koki the opportunity to arrive?
Okay. So Koki's the one that we're waiting for?
Yes, sir.
All right.
Would you like to begin? Would you like to?
Yeah, I don't think it'll matter if she comes in a few minutes late on this. All right, so I'm going to reconvene this session at 1:38 is what it. No, 1:38 is what it looks like to me. So here we are. Okay, so our first order of business will be item number 14, and formal complaint hearing. And for that, I will be turning the meeting over to Mr. Alex Leader in Las Vegas. So it's all yours.
Thank you, Mr. Nixdorf. This is an agenda item number 14, and the board will consider a complaint hearing under case number C-14-800. Because you may not have been present earlier when I did the overview, I'll just familiarize you with the complaint process just quickly while we're to give you an idea of that how you would be representing your own establishment. Our Deputy Attorney General, Sarah Bradley, will present the board's and staff case, and then she will enter exhibits into the record and call witnesses to testify. One of those witnesses being the inspector. After all the testimony by each of these witnesses is complete, then you will be allowed, or your attorney, Mr. Taylor, will be allowed to ask questions of the inspector or any other witness. And then the board members may question the witnesses. You or your representative, your attorney, will then be allowed to call any additional witnesses to testify or enter exhibits on your behalf for the record. Okay. These additional witnesses will also present testimony, and the Deputy Attorney General, Ms. Bradley, will then be allowed to ask questions of those witnesses, and finally, the board members will be able to ask questions of those witnesses, and then finally, the Deputy Attorney General will be allowed to make any closing comments, as will you or your representative, Mr. Taylor. The public evidence of the portion would then be closed after those closing statements or final comments, and the board members will go ahead and then deliberate your case. That motion will then be made, or a motion will then be made regarding the disciplinary action, and if there would be any fines associated to that action. And then that would be a final vote of the board. Okay. Did you have any questions regarding that? Okay. Mr. Taylor, did you have any questions regarding that process? No, evidently.
We can't hear you. I think you're speaking, but maybe the microphone button's not pushed.
And I know better. I'm sorry. There was an earlier citation, DB 81, and staff up here said I could look at it apparently once we began. I'd just like to take a quick look so that I've covered myself on that. But other than that, we understand the process, and we're basically ready to go forward.
What is it that he's referring to, the DB81? What is that?
That was the previous citation.
Are you referring to an exhibit?
No, I'm referring to the previous citation, which brings us here because this becomes the second citation. You won't have it in front of you.
Okay. Will you be presenting that first citation
as
an exhibit?
But I wanted to see what it was for, to see whether or not it was in any way relevant to the present charges. So, and I can take a look at it as we're going forward. It needn't delay us any.
Okay. And so at this time, I would just like to introduce Kimberly Arguello. She's a senior deputy attorney general, and she represents the board's interest in this particular matter. I introduce her because she was not here in the earlier complaint hearings. At this time, I will ask that all the parties please stand, including you, Mr. Taylor. I guess attorneys don't necessarily need to be sworn in. But if you could please stand and spell your names, please, and then you turn your mic lights on, and Mr. Nelson will take your test, or swear you in, rather.
Just say my first and last name and spell it.
Please.
Okay. Connie Pena, CONNIE,
Pamela Fitzgerald, PAMELA FITZGERALD.
Please remain standing.
Thank you, Ms. Pena.
At this time, I would like to just go ahead and turn this matter over to you, Ms. Bradley, please.
Thank you. Mr. Taylor, I know I sent you by email the five exhibits I intended to admit today. I didn't know if you had a chance to look those over and if you have any objections to any of the 5.
What I'm going to suggest is I may have a couple of questions regarding those exhibits of Ms. Pena, and let me suggest that if you offer them in your case in chief, but we reserve ruling till I have a chance to ask her a couple of questions. I think they're eventually going to come in, but that way we could have a full discussion of the exhibits before they are actually admitted.
Do you have any objection? I've labeled the amended complaint notice of hearing as Exhibit 1, so I'm hoping you'll agree to that one.
No problem.
And then we'll start. I just do that for the record.
Right. The only one I may have objection to, frankly, is probably this roll of material in the pictures. With regards to, hang on, what are we at here? Hang on. With regards to exhibits 1, 2, 3, and 5, I have no objection.
Okay, so then maybe just to make it easier for the board, I would then ask that 1, 2, 3, and 5 be admitted. That way they can be passed out to the board, and then we'll go ahead and we'll do Exhibit 4 later.
Okay.
When I have my witness testifying.
Yes, that's fine.
Thank you.
That's fine.
And so admitted. And Mr. Nixdorf, you're also getting a copy of those exhibits?
I am.
But Ms. Marsh, please.
Okay.
And please make sure that Mr. Nixdorf does not get number 4 yet. I just want to make sure.
She's done so.
And if I may ask a question, I had in fact filed an answer, but it came in late. Did that in fact get to the board or not?
We do have copies here, and we will provide that to the board. I don't believe it was in their packet, and I don't have any objection if we provide the answer to the board members now. I know Ms. Bradford has copies here, so once she's done with these exhibits, I'll ask that she provide the answer to the board members.
Okay,
And so is that so admitted?
So late.
So the answer will be considered Exhibit 6?
Great,
it would actually be, if you want to label it, it would be maybe Respondents A. That way
Sure.
we can be clear. Mine will be numbers, and theirs will be letters.
Yeah, that'll be fine.
So Respondents Exhibit A is so admitted?
Yes. Lots of papers. How it is. It's a pretty bracelet. Oh, that's nice.
Ms. Bradley, I'm also noticing then that in Exhibit 2, that it does refer to citation DB81. Is that going to be an exhibit?
I don't have a specific exhibit on DB81 because that's not really, that's just the reason we're here on a second. Ms. Ball may have some information, or I'm sorry, Ms. Fitzgerald Hayes may have some information on that, and Ms. Ball is the one who issued that citation. So we may have information if we need that, but my case in chief doesn't rely on that citation much at all.
Thank you.
Well, and if I may be clear, I was just, if the file was here, I was going to take a look at it. It's part of my due diligence. I didn't expect us to really get into the details of that. That's really what I'm just trying to do my job on that. So I don't plan to be talking about it at all. I just wanted to take a look at it if it was available. If it's not available, I don't expect us to get into it.
Thank you. Any other preliminary questions or?
So I wanted to give Ms. Bradford a minute, though. I think she's handing out the answer, or maybe she's done. Okay, so all the exhibits that have been admitted, 1, 2, 3, and 5 have been handed out, as well as Respondents A.
Yes.
Okay. Then I will proceed, and I would call Ms. Fitzgerald. Would you please state your name and spell your last name for the record?
Pamela Fitzgerald, Fitzgerald.
And who is your employer?
Nevada State Board of Cosmetology.
And what is your job title?
Inspector 2.
Did you issue did you do the inspection that brings us here today in this case?
Yes.
And can you tell us about that?
These are administrative hearings, but asking for a narrative is a bit concerning to me.
Thank you for your comment. It is customary in our administrative hearing that the inspector provide the background.
Sure.
Okay. Well, I can ask more detailed questions. So what day did you do the inspection that brings us here today, Ms. Fitzgerald?
January the 10th, 2014.
And why did you go to the salon on that day?
We received a complaint of unlicensed persons working in the salon and unlicensed unsanitary waxing room, and that's why I was out to do an inspection.
Okay.
Unsanitary waxing room, I'm sorry.
So prior to your inspection, you'd received a complaint about the salon?
Yes.
And so during your inspection, what did you see? Yeah, go ahead and tell us, what items did you cite for or were you concerned about in your inspection?
Where it says instruments and implements, the anonymous complaint received, which was January the 8th, 2014, alleging unsanitary instruments, implements in waxing room. Present in waxing room, I found stained and used cotton balls, waxing strips, and what appears to be blood on a piece of cotton inside a closed container with unsanitary tweezers present. I also found the waxing pots in unsanitary conditions for public use. The waxing pots had a heavy buildup present, so the complaint was valid. I issued PF 223 and it to the owner for violating the above NAC 644.340, which was a second offense, and according to the law, the owner must appear at a disciplinary board hearing. So that's why we're here today.
Okay.
And photographs were taken.
And that's what I was going to ask you. So you took photographs on that day. Now I'm showing you what's been pre-marked as the state's Exhibit 4. Do you recognize this top photo here?
Yes.
And is this a true and correct photo of what you saw on that day?
Yes, ma'am.
And then if we go to the second photo, it looks like it's maybe some wood. Is this also a true and correct photo of what you saw on that day?
Yes.
And you took both of these photos?
Yes, ma'am.
And then we have a third photo here, and it says stained waxing strips. Is this a photo that you took on January 10, 2014?
Yes.
And is this a true and correct photo of what you saw on that day?
Yes.
We're now on photograph number 4, and is this a true and correct copy of a photo you took of a waxing pot on that day of the inspection?
Yes.
And this is what it looked like to you on that day?
Yes.
And then the last photo is also a waxing pot. Is this also a photo you took?
Yes.
And is this a true and correct copy of what it looked to you on that day?
Yes.
I would ask that based on Ms. Fitzgerald's testimony, that Exhibit 4 be admitted for the board to look at.
Mr. Taylor, do you have an objection to Exhibit 4 being admitted into evidence?
At this time, without further questioning, I have an objection to the first picture, the one that has the tweezers in it. I have no objection to the second one, which is the wood area. I have an objection to what is designated stained waxing strips, the third picture. I have no objection to the two pictures of the waxing apparatus. So there are only two that I have concerns about at this point.
And so what is the objection to picture number 1 and picture number 3?
Well, picture number 1, we have no knowledge of that item being in the waxing room or why it would be in the waxing room or who would have brought it into the waxing room. And I would just like the opportunity to ask a couple of questions of the investigator regarding the condition it was found and where it was found. Likewise, as to the waxing strips, since, as far as we can tell from appearance, or my client can tell from appearance, since these are not the waxing strips which are normally used in that waxing room, I have some question in terms of where it was found, the condition it was found. And I'd simply like to voir dire on that a little bit.
Thank you. So in terms of the exhibits being presented, it's on the photographs, there were 6?
I believe there's actually 5 photographs
5.
here.
So photographs 2, 4, and 5 are admitted, and photographs 1 and 3 have yet to be exhibited.
Yeah, but let's not pass them out yet because they are all stapled into one packet. So I have no objection to Mr. Taylor asking the inspector some questions, and then maybe he may change his objection. I'm not sure.
Okay, so we'll continue with testimony. Ms. Bradley?
So then I think
so Mr. Taylor, would you like to ask questions of the inspector?
Thank
Ball?
you.
just regarding these photos.
Right, I understand, and I appreciate the opportunity of doing it now. With regards, Ms. Fitzgerald, with regards to what is shown in the first photograph, the one that has the tweezers, I gather this is some sort of a plastic box, is that right?
Yes.
And where was this plastic box found?
On top of the counter.
On top of a counter?
In the waxing room.
In the waxing room. And was it found open this way?
It was found exactly as the photograph is here. It was open. The cotton was here, exactly where you see it, the tweezers, so I took the picture.
Okay. And when you went into the waxing room, was there anybody in the waxing room?
Not at the moment. Not inside the waxing room, no.
Okay. And at any time, were there other people present in the salon at the time that you found this item?
Yes, Barbara Gill, who's the cosmetologist in charge. Who was the cosmetologist in charge.
And anyone else?
There were several people there, but they were not in the room. Barbara was the only one who was actually standing by the door.
Well, was she in the room or was she standing by the door?
She was standing one leg in the room, one leg, she was in the middle of the door.
Okay. Did you ask Barbara Hill whether or not this box belonged to her?
No.
Did you ask her if she had any knowledge of where how this box came to be in the waxing room?
No.
Okay. And therefore, I'm assuming, did you ask anybody else how this particular box came to be in the waxing room?
No.
Okay. Now, with regards to the stained waxing strip, this is and I'm sorry, the only thing I know about waxing is what I saw in Sex and the City, so excuse me if if I have to ask some pretty basic questions. It looks to me like this strip is actually coming off a roll of this material. Is that correct?
That's correct.
It is. And there is some sort of staining on the strip. Were you able to determine what the stain was?
Honestly, no. That's why I took the photograph, because I wasn't really sure.
Okay.
I'm not quite sure what that is.
Okay.
It looks like blood, then it looks like wax. I wasn't really sure. That's why I noted on the report.
Okay. And this particular roll, where was this roll located?
On top of the closed plastic container.
In the closed plastic, the closed plastic.
Yeah, closed plastic container, yes. Sitting on top.
Okay, and what was in the closed plastic container? Do you know?
I didn't open that. No.
Okay. And this closed plastic container, again, where was that in relation to the rest of the room?
Sitting on the counter.
The same counter as you found that other box, the plastic box?
Yes.
Okay.
Yes.
All right. And were there any receptacles in the room for disposal of, I don't know, any sort of garbage or any sort of used materials?
No. I don't recall.
All right. Certainly, it would be fair to say that you.
Hold on.
And by the way, if you need.
You said close.
By the way, if
Go
you
ahead.
need time to look at your report to answer these questions, please do. I'm not trying to.
Can you repeat the question again, please?
Yeah, here's what I'm really asking. So let me ask it this way.
Okay.
Did you find in any receptacles in the waxing room any used strips of waxing? Any used waxing strips, that is, waxing strips that have been cut off for use, used, and then disposed in any kind of receptacle?
There was closed waste receptacles in the room. Yes, it was.
Okay.
It was a trash can that had a cover. And honestly, I don't remember, I don't recall.
Okay. Okay. Well, let's do it this way. Was there any sort of supplies, cabinet or container in the waxing room?
There was a closed cabinet that had towels. The cabinet was closed. I did open that up. It was towels inside of there. The container that you see on this particular picture that we're looking at, you could actually see that there were waxing sticks that were inside the closed container, but I did not open that closed container. So yeah, there were several. I think it had 3 in this particular container here, and then the closed cabinet for the clean towels.
Okay. And did you note any other waxing strips in the waxing room other than this roll?
No.
Okay.
No.
Does this assist you in identifying whether or not photographs 1 and 3 can now be entered as exhibits?
I'm sorry that I have to do this, but I do have to object to 1 and 3. We don't know the source of these exhibits, and therefore there's an objection with regards to whether or not these, in fact, demonstrate unsanitary practices that were under the control of Mia Bello's salon. So yes, there is an objection to those two.
I would just respond that the inspector has testified that she saw these items in the salon on that day in the waxing room, and she took the pictures just as it was. So, for example, on the first photo, she says that the box appeared just like that. She didn't open it. She didn't touch it. And that's where she found it. And then the waxing strips were also, she said, in that same room in the exact location where she photographed them. So I would say, based on her testimony under oath, that these are photos she took on that day. They're true and correct copies of what she saw on that day in the salon. I would ask that they all be admitted in full.
At this, are there questions from the board regarding these photographs?
One question. Did somebody sign this form here that said these pictures were taken? Did somebody?
Normally, and I apologize, normally there's been I've asked to move this into admit evidence as Exhibit 4. There's been an objection to that. You've heard both of our arguments, and normally now the chair would decide whether or not this is admitted, and then you would either get to see it or you wouldn't, and then perhaps the board member can ask a question about it later when it's time for board member questions.
At this time, there has been some satisfactory authentication of the photographs. There is insufficient reason to believe that the inspector had photographs from any other source other than your client's establishment. The exhibits of the photographs 1 through 5 are so admitted as evidence.
And maybe very
and then
clear,
for the record,
I'm not
that's
implying
Exhibit 4.
And may I imply? I'm not implying that these were photographs from someplace else. at all. I mean,
And that's
that
quite
was
all
not my
right. We
implication.
have,
All right.
and we have
Don't give me any more trouble.
satisfactorily authenticated them. So they're now evidence for us and for you.
Thank you.
Would you like to then continue with questioning, Ms. Bradley?
Yes, so Ms.
so you'll-
Fitzgerald is still on the stand.
Pass them.
Yes, and please pass out Exhibit 4, both in Carson City and in Las Vegas.
And then, Mr. Nelson, also please let the record show that earlier I referred to Inspector Hayes Fitzgerald as Inspector Ball in error, pardon me. And to please let the record show that I know who I'm referring to. Sorry, Ms. Fitzgerald. Pardon me.
So, Ms. Fitzgerald, how many inspections do you normally do of salons in a week?
In a week?
Mm-hmm.
I would say 6 times 4, anywhere between 24, 30. It just depends.
And how long have you worked for the board?
As a matter of fact, November the 24th will be my 9th year.
Okay. So, doing inspections of salons is something that you frequently do and you're familiar with that?
Yes, ma'am.
And so, were these violations concerning to you in this case?
Yes, ma'am.
And that's why the citation was issued?
Yes, ma'am.
Thank you. I have no further questions for Ms. Fitzgerald at this time, although I do reserve the right to recall her should I need to in rebuttal.
Thank you. Mr. Taylor?
Thank you.
Would you or your client like to continue any questioning of Inspector Fitzgerald?
Yes, I have a couple of questions, if I may. Ms. Fitzgerald, you, when you did your inspection, you in fact found 2 people who were unlicensed in the facility that you cited. Is that correct?
Yes, sir.
Okay. Now, the anonymous complaint you received, you had indicated it was regarding unsanitary instruments and implements in the waxing room. Did it, in fact, did the anonymous complaint say anything about unlicensed individuals?
Yes.
Could I see where in your report that's contained?
On the report written January the 10th, 2014, it says all licensed individual. It's NRS 644-190.2. Complaint received 1/8/2014 alleging unlicensed person working in salon. Complaint valid. Upon arrival, I observed a young lady sitting in the first nail station when I walked in.
I'm sorry, this is beyond the scope of my question. Which exhibit are you looking at?
I think it's Exhibit 3.
Exhibit 3. Here.
Okay.
So it's dated 1/10 of 2014.
If I may have just a moment.
She's looking at the bottom box commentary.
Oh, I see. You're looking at the second page. I see. I'm sorry. My error.
Yes.
Okay. The complaint mentions cotton balls. Are there any pictures of the cotton balls?
No. I don't know any exhibits that he has. These are the only ones he has, right?
Yeah.
Yeah.
With regards to the, where were the cotton balls found?
I'm sorry, Mr. Taylor, could you repeat that?
Yes, where were the cotton balls found?
Where were the cotton balls found?
Yes, where were they located? I've got an allegation of stained cotton balls. I'm just asking where they were.
Yeah. Well, actually, on this one picture it says exhibit number 4. They kind of on the side, so it did get cut off a little bit. So you don't have a picture of the actual cotton balls. But I remember exactly where they were. But you don't have a picture, so.
So
You
the
won't
cotton
find one.
balls. So the cotton balls were near the wax heating units.
It was used cotton balls, which they had been used, and this actual exhibit number 4 on the side of the plastic container where the cotton balls, they had been used. They were just sitting there. But unfortunately, on this picture, you don't have the cotton balls, but they were sitting on the side of this exhibit number 4, the plastic container.
So we're back to we're talking about the first picture in Exhibit 4, the one that has the tweezers.
Yes.
All right.
Yes.
Were they inside or outside of that box?
They were sitting on the counter on the outside of the box of the
Okay.
plastic container.
All right. How many were there? And were there a lot? Were there a little? What? You know?
I think it was maybe 2 or 3. It wasn't a
Okay.
whole lot.
Okay. So one of the allegations in this case is it says the board staff believes and therefore alleges that reuse and or failure to properly dispose of used single items is required by law, such as cotton balls and waxing strips, a cost-saving and time-saving strategy employed by the respondent. How much are cotton balls? And
you
I
asking
gather
me the question, how much
go ahead, I'm sorry.
Were you asking me how much cotton balls cost?
Yeah, I'm wondering why staff came to the conclusion that somehow we would try to save money by not using, by reusing cotton balls. Was there a financial basis for that?
I'm not sure that that has been established at all. I think what was established is that the cotton balls were soiled with blood, not that there was any cost mechanism involved in that.
It's actually alleged in the complaint, though, Mr. Leader, if you go to page 3 of the complaint. So what Mr. Taylor's doing is asking the inspector about something that's contained in the complaint and notice of hearing.
But that wasn't what the interpretation that I received from the report of the salon establishment, though.
And if we can stipulate that paragraph 11 will not be considered by the board, I mean, I don't want to waste time on cotton balls, but it's in the allegations.
I think that number 11 says properly dispose of single-use items. So I think it's a two-part question, and you might be just isolating one component of the item number 11. I'm not quite sure if you're emphasizing cost savings, which is the last sentence, as opposed to rather than emphasizing properly dispose of, which is the preceding sentence.
Well, the properly dispose...
But you can continue questioning.
Well, the properly disposed, if I may, Mr. Chairman, the properly disposed of issue is contained elsewhere in the complaint. We don't need to have it repeated. The crux of paragraph 11 is somehow cotton balls and waxing strips, the reuse of them was cost-saving or time-saving strategy employed by the respondent. Given what is at least a layperson as myself knows about the cost of cotton balls, I'm just looking for a basis that could, because it's in the allegation to be used against my client. So
please continue with your questioning.
Well, same question. Let's do it this way. Ms. Fitzgerald, do you have anything to do with the allegation, the complaint that somehow the cotton balls, reusing cotton balls or waxing strips was a cost-saving or time-saving strategy employed by the respondent?
No. Totally confused on what he's asking me.
Asked and answered no.
No? Okay, that's fine.
Yeah.
May I say something? Okay.
I think you may have to ask Mr. Taylor.
Oh, okay.
But ask him. It's okay.
No, I think the reason
it's
why
just administrative
wait.
hearing. So
hang
ask-
on. We're going to get to your testimony.
Oh, okay.
I'm going to ask the audience to please be quiet and respectful during this hearing. Thank you.
Oh.
Can we take a couple-minute recess? Ms. Pena would like to use the ladies' room before we continue.
Yeah, please. So at this time, the time is 2:13, and we will adjourn for just roughly a few minutes.
I'm not going to drag this out all afternoon, I swear. Do you have hearings after this one? That's what I thought. All right. All right, let me get some quick.
I'm sorry, I don't. I thought it was with the packet. That don't.
Like I said, I'm just covering myself and stuff. It's okay.
Mr. Taylor and Mr. Nixdorf we're going to reassemble and call this meeting back to order at 2:17. Mr. Taylor, you were engaged in a line of questioning of the inspector, Ms. Fitzgerald. If you'd like to just continue.
Yes, only one or two questions. I realize that's dangerous when an attorney says that, but I will try to keep it to that. Ms. Fitzgerald, at any point did Ms. Pena offer to assist you in locating Damaris Lopez?
Yes.
Okay.
Yes, she did.
Fine. Thank you. At this point, I have no further questions of this witness.
Thank you.
I do have a couple redirect if I could.
And the
witness.
redirects happen before board questions? Yes. Please.
Thank you. Ms. Fitzgerald, you stated that you worked for the board for 9 years and you do about 24 inspections per week. Or more. Okay. And what about your training as an inspector? Have you had training?
Oh, God, yeah. We've,
we will stipulate to her qualifications. We'll stipulate to her qualifications.
Okay, then I'll just skip right to my question then. So if we go to item number 11 in the complaint notice of hearing.
Yes.
And I believe you testified previously that there were garbage cans in the waxing room.
Mm-hmm.
So can you think of possible reasons why individuals might reuse single-use items?
Calls for speculation. You've asked.
Well, I would just call that she's, as a person who does inspections all the time and has been trained in this area and goes into at least 24 salons a week, I think she's qualified to provide possible reasons why an individual may reuse items. And so that's why I'm asking her.
Well,
I'd like to hear what the possible reasons might be, so I'll overrule your objection. Ms. Fitzgerald?
A lot of people do it to save money.
Are there other reasons, Ms. Fitzgerald?
Lazy. Just being honest.
Does it save time?
Time, yeah.
Okay.
Yeah, it could be several things. I can't speak for other people, honestly, but a lot of people are just lazy.
So in your experience, it would be most likely due to laziness or to save time,
And to save time
or to
and try
save
to
money.
get a service done so they can get another service done so it can, just keep getting them in and getting them in and getting them in. So I don't know.
Okay. But it's a reasonable belief. You believe that number 11 is a reasonable conclusion that you could draw based on what you saw in the salon on that day?
Yeah.
And if you look at...
Yes and no. But it's all right. My very first thing was no, but it could be yes and no to that particular here. Because some salons are better than others. So I have to be fair.
Mm-hmm.
You understand what I'm saying? But this particular day, this was just somebody being lazy. And this is just somebody trying to save time, I'm sure. And somebody doing something they should have been doing.
But is the trash can close to where these items were found?
There was a closed waste receptacle in the room.
So it wouldn't take much to throw them away?
No.
So it sounds like maybe more than laziness.
Possibly.
Okay.
I'm sorry, is counsel arguing? Counsel said so it's something more than laziness. That's argumentative.
All right, I would withdraw that statement then.
Thank you.
From the record. I have no further questions for Ms. Fitzgerald.
Thank you.
And so at this time, is there a redirect from Mr. Taylor? Or if you have some additional questions, Mr. Taylor.
I'm not going to drag this out any further. I'll make my comments in closing argument with regards to this issue.
Thank you very much. And then board members, Mr. Nixdorf, maybe I'll start with you if you have any questions, comments, or discussion.
Yes, I do.
And this is for questions of Mrs. Fitzgerald.
Yes.
Questions of the inspector.
Correct. Ms. Fitzgerald, I see that these items are clearly used, but I'm not so sure about the reused portion of it. What makes you believe that these items were reused and not just used and discarded onto the table?
Reused, where is that in my report?
We have an allegation.
Which one?
Item number 12, it says it says that it's the reuse and or failure to properly dispose of. Is there any belief that this was a reuse, or is it just failure to dispose of properly?
According to my report, it does not say reuse.
No, I'm talking about the in the factual allegations, item number 12. We're talking. It says reuse and or failure, and I was just wondering if there's a reuse in this, or if it's just and only a failure to properly dispose of that you were able to see.
Well, first of all, my report does not say reuse, so I'm not really sure what this is stating. Is this the report that we give to them?
This is the complaint.
Okay.
This exhibit is the complaint notice of hearing that the board sees.
Okay.
In 12, it says clearly and or. So I think
Use and or.
Or and
right.
Or.
Okay.
So you didn't
that's
see.
what we're looking at.
Okay.
Yeah, I'm just asking if there's any evidence that it was reused or if it was just improperly
used.
disposed of.
Used.
Thank you. No more questions.
It was a single-use item which had been used and not discarded. That's what it was.
Thank
Mrs.
you.
Fitzgerald, Jeanette
Yes.
Benaldi here. So
Yes.
we were just looking at the NAC 644-340 in 1C.
Mm-hmm.
And it's stating all disinfected instruments, implements, and other tools that are not in use and not in the process of wet disinfection in a wet sanitizer must be stored in a clean, dry sanitizer.
Yes.
Okay, that's just the law, right? Okay,
Mhm.
thank you.
And I'm going to ask, was that the case?
Oh.
Okay. Any other board questions of Ms. Fitzgerald, the inspector, the witness for the State Board of Cosmetology? Is there, at this time, did you have other questions or any summary comments?
I have no further witnesses, but I would like to ask a clarifying question of her based on the board questions. Because I think somehow we were confused here. You testified previously that you saw the wax be dipped in the same pot, did you not?
No. That was Diana before me.
Okay.
Who was that was another case.
Okay, I'm sorry. I must be misremembering, then I
That's
apologize.
quite all right. That's quite all right. Mr. Taylor, now are any other questions or of the witness, of the inspector?
No.
Mr. Nixdorf? Thank you. Mr. Taylor, now is an opportunity for you to present your client, Ms. Pena's case.
Thank you. Ms. Pena, at the time this inspection occurred on January 10th of this year, were you in the country at that time?
No.
And when had you left the country?
January 7th, 2014.
Okay. And were you going out of the country at least in part for a professional reason?
Yes.
And what was that reason?
Part of a association, Promotores Unidos. I'm a promoter in the Latin community, and we have quarterly meetings.
Okay.
So I had to go attend.
And you were also going to take advantage of the trip to see some family too, right?
Correct. My family's from Quintana Roo in Yucatan, Mexico.
Okay. Now, when was the last time, were you in the shop just prior to your leaving on this trip?
Yes.
So you've seen the pictures of the wax room, right? And the items that were
Correct.
found. Okay. Let me finish the
Yes.
question, okay? And with regards to this, with regards to the box, which is that first question, the one that has the tweezers, at the time you were there, was that box present?
No.
Have you ever seen that box in Mia Bella's salon?
Never.
Okay. Now, with regards to, there are what appear to be wax stains on the floor of the waxing room. What efforts did you take to maintain the cleanliness of the waxing room?
When I returned from Mexico, what we did is we had it, well, before I even got back, it was completely cleaned. It wasn't in this condition at all. But we've tossed out the wax spots, pot that was found there that day. We have a list of who uses the wax room after, every use. We completely remodeled the room. Actually, I'm no longer there, but after, when I got back, that's what we did to take care of that situation of that room.
Okay. But with regards to the floor, when you left to go on your trip, was the floor in that condition or anything approximating that condition?
The floor wasn't in that condition, and it wasn't in that condition when I got back either.
Well, had you ordered cleaning crew in the meantime?
I didn't order anybody to come in. Actually, nobody worked. When I returned, there was nobody working anymore because we had been closed.
All right. With
shut down.
I'm sorry. With regards to the this wax strip, which is in the picture, to your knowledge, is this the kind of wax strip that was used in Mia Bella?
No, I actually bought samples of what we use.
Wait. Let me rephrase the question. If someone was using the supplies at Mia Bella, would this have been the waxing strip that they would have used, the kind of waxing strip they would have used?
No.
And these waxing pots, in fact, have been gotten rid of, right?
Correct.
And am I right that there is a way to prevent the buildup of wax on waxing pots?
Yes.
And what is that?
To use the neck.
Okay, so
around it, and it's a piece of
collar.
Collar. Sorry,
collar.
Español es el cuello. The collar around the wax pot, which we do have and we do use. I don't know why they're not there in this picture.
Okay, so if somebody was following the procedures that were normally done at Mia Bella in the wax room, should they have used a collar on this pot?
Every time, yes.
Okay. Do you have any idea who used these pots prior to the inspection on the 10th? Well, let me withdraw the question. Do you know who was responsible for this mess?
Do I know who's responsible for it?
Yeah, I mean, who
was that your question?
Yeah, who made this mess? Do you know?
It wasn't any of our staff. We had a renter there, but it wasn't any of our commission workers. Okay. So yes.
So anybody who left this kind of mess in the waxing room, would it be fair to say they were not following the normal procedures at Mia Bella?
Yes.
Okay. And was it your intent that cotton balls or waxing strips or anything like that should somehow be used or should be not properly disposed of in order to save money or save time?
No, there's no reason for that. We don't even use cotton balls.
Okay, what do you use instead?
They're swaps, but they're not, the round, typical cotton balls. And, well, I'll speak later, but go ahead. That was it. We don't use cotton balls, but yes, everything gets tossed out as soon as it's done.
Okay. And again, what kind of waxing strips were used at Mia Bella if they were using the supplies that were there?
Show you. This is the roll that we use. Exactly what we use. It's cloth. This is what was found, which is muslin. Muslin we do not use because everything goes right through it. I just don't like to use it, so I always buy this one. I don't know whose on exhibit, was it number 3? The stained one, I don't know whose that is. I know, and actually, this is the same one because it was underneath, thrown in the back. And I think that's why you asked, where did she find this? Because we still have it. I don't use it, and I saved it as evidence. It just gets stained too fast. It doesn't hold. It doesn't grip off. So to answer your question, what I use is cloth.
Good. When you left to go on your trip, to your knowledge, were there any unlicensed individuals doing work in the salon that they needed to be licensed for? Understand the
Can
question?
you repeat that question?
Sure.
Yeah. No, repeat that question again.
Yeah, lawyers sometimes ask convoluted questions. Obviously, there are duties which are covered by the practice of cosmetology, right? That you need a license for.
Correct.
To your knowledge, was there anyone performing cosmetology at Mia Bella when you left who was not licensed to do so?
No.
Okay. So, if you would, why don't you explain to the board what actions you took after this investigation and after these citations were issued?
Sure. When I returned, we had been closed for several weeks. I negotiated a contract with my attorney to shut down half of the salon, which is that half that we were cited for where the wax room was. That was a renter side. I now only own half of my salon, and we have a whole new room with new equipment. There's a reporting list a report where everybody has to sign in if they use that particular wax room. We also, that's where it's for facials. So everything has always been inside a cabinet or in a container looking like this. And earlier, I know Ms. Fitzgerald said she found this on top of the counter. In this particular room, it wasn't on a counter. It was on, if you see those rails, they're actually on the wall. And I think that's why Mr. Fitzgerald was saying, can we not have this part of it? Because we don't use this. We think this was found somewhere else. But anyways, we no longer have anything exposed. Everything is inside of a container or a cabinet, closed. Everything's just new. It's completely different, the room, and we don't have anybody that is not Mia Bella cosmetologist use that room, period. If they rent or if they do not, they don't have access to that room.
Now, there's another violation here. At some point, Mia Bella allowed their license to lapse. Is that correct?
Correct.
Okay. And any idea, was it your responsibility to make sure you're the owner. It's your responsibility to make sure the license is current, right?
Yes. At that point, I had a manager. So the manager let it lapse.
Okay. But you're taking responsibility for that now, right?
Oh, absolutely, yeah. Now I'm in charge of my salon. I'm there 5-6 days a week while we're open. Before I had more projects on my hand. I owned a nightclub. I was a promoter. Now I just dedicate myself to my salon.
Okay. I think those are all the questions I have at this point.
Ms. Bradley, did you have a cross-examination?
I do. And I'm sorry, I'm probably going to mispronounce your last name. Pena?
Pena.
Mm-hmm. Pena. Ms. Pena, are you aware of the laws and regulations governing cosmetology?
Yes, I am.
And so when you left to go on your trip, did you have
cosmetologist or nail technologist in charge at the salon?
A cosmetologist.
And so you're aware of that requirement?
Yes.
And so is it your testimony then that that's the person that's responsible for the violations in this case?
You know, in this case, I was in the middle of a sale, and the manager, the office manager that was supposed to be in charge of overseeing everything, was not licensed. She was going to be the new owner. We were in negotiations. We had already came to an agreement, and she had been renting out because she was going to open a business within my business. So I left a cosmetologist in charge, but there was still a managing role as far as like office work goes. And she was the one that was supposed to be in charge of overseeing the cleanliness, the open and closing of the time, the licensing, accounting, payroll. She was in charge of that. But yes, to answer your question, I do.
But you just testified, I believe, that that person was not licensed.
That person was not licensed.
Okay, so you expected that person to be aware of the laws when the person was not a licensee?
I'm not licensed either, and I don't do hair.
Okay. I have no further questions.
Any board members have questions of Mr. Taylor or his client, Ms. Pena?
Hi, Ms. Pena. Hello. So this person you were selling the property to, did you have a LOI or a lease agreement signed?
No, I had a rental per chair agreement, and the first page is there. I had it signed. I have passport signature, how many chairs she was going to rent, and the negotiation of the sale of the salon was not signed because we were still working that out. We came to a verbal agreement on the purchase of the salon, but I do have where she said she would rent out the stations.
But at the date in question, you still own the salon? Then?
Correct, yeah, I do.
Thank you.
Mr. Nixdorf, did you have any questions of Mr. Taylor or Ms. Pena?
Not at this time.
Any other board members with any questions? Please, Ms. Booth.
Ms. Pena, there was some unlicensed, I'm trying to follow you here too. You had a cosmetologist in charge.
Correct.
So she would understand that you couldn't have unlicensed people working there. Is that correct?
Yes, that's correct.
Okay. So how did those unlicensed people get into the salon and were working there for the day if you had somebody in charge?
Unfortunately, when I left, Ms. Crawford decided to take into her own hands, I guess, how do you say, aprovechar?
Who is Ms. Crawford?
One of the ladies that were called, the renter, the one that was going to buy my salon. She brought in her team. She hired. And even Barbara, the licensed Cosmo at that time, said, I didn't know she was going to do this. I couldn't do anything about it. You weren't here. I couldn't do anything about it. So it's a very difficult situation, but Ms. Crawford had people working there.
So it's your understanding of the law that if you're not there, that the licensed cosmetologist can't do anything either? I mean, the only one that could do something would be you? Is that what you're telling me?
No. What I mean is Barbara, the licensed cosmetologist, had nothing to do with Miss Crawford being there or the other person she had working.
Okay, but did she oversee the salon?
She was the responsible one as far as like...
So when somebody came into the salon, she didn't check to see if they had a license?
No, she didn't.
Okay, thank you.
Sure.
Any other questions of Mr. Taylor or Ms. Pena? I did.
I have one.
Okay.
I'm sorry?
Could I ask her a question?
Is that Mr. Nixdorf?
Yes.
Yeah. Go for it.
Ms. Pena, so I'm trying to get my head wrapped around the time frame here. There's only been like 3 or 4 days after you were out of town that this citation was issued. And the way I read it is that you left and this renter brought in her own crew almost immediately as soon as you got on the airplane, pretty much, right? And began running or renting out her stations because in theory she thought she was renting and then subletting from you. Is that how that goes? I'm not following this business relationship that you have with her and how she would bring someone else in to work. Could you clarify that for me?
Yes. What she wanted to do was rent out 4 chairs and then eventually buy out. So meanwhile, what she was doing was renting out a certain amount of chairs, and she had licensed workers there. She only had 2 though. She wasn't able to fill it in. She had 2 gals that were working there, and they were licensed. So when I left, I got called. I found out that there was a girl working there that wasn't licensed. And Yahaira wasn't doing hair, but apparently they found her doing hair. So it's not like I rented it to her as a cosmetologist, because I even have, signed paperwork. I wouldn't have her working for, doing hair. But she clearly said, and she even opened her own salon, a DBA under Yo Soy Hair Salon, because she said, I want to be like you, where I'm not doing hair. I'm just running the business. It has tons of potential. I like this location, blah, 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 blah. So she was not supposed to be doing hair. And she even told me that day when I called, she says, Connie, I wasn't doing hair. But in Ms. Fitzgerald's report, it says that she was doing hair. She said she had somebody sitting down and she was talking to her. And she's like, I wasn't doing hair. But I don't understand because I don't speak English. I couldn't defend myself. That's a whole nother case right there. But that's what she told me.
Okay, thank you very much.
Ms. Pena, in your earlier testimony, you had indicated that you had, as part of the, cleaning up from the citation, that you tossed the wax pots.
Correct.
And so the wax pots were like this picture 4 and 5. So why did you toss those?
Because they were disgusting when I saw this. I mean, I'm not going to reuse this.
So
we
it
don't
would
reuse
be fair
anything.
to say that they possibly were unsanitary.
It is. They, from what I see here and what I did see, there was wax. Obviously, when I got back, there wasn't this kind of residue. But underneath the lids, they were burnt. So I tossed those. Because when I got back, I didn't see this. You see what I'm saying? When I was present, I didn't see it. Now, Barbara, the licensing question, she said she didn't get to go inside the room, that she didn't see. She told me I was not in there. They asked us to wait in the front, and that's where apparently the people were. So when I got back, the last meeting we had, the first time I ever saw the pictures was this. That's why I said that's not my pot, because what I saw and the one I tossed didn't have all this buildup. It only had underneath the lid, like if it had been, really yellowy. But either way, we tossed them.
And then there's several references to the stained or used cotton balls. And just as a matter of formality, do you feel that in the exhibit pictures, the picture number 1, that it's a photograph of maybe a cotton pad? And that cotton ball might just be a summary statement for the use of just various types of cottons in the salon?
It's not even a cotton pad. It looks like a gauze to me.
So like a gauze pad?
It looks like a gauze.
Do you think that those could be used interchangeably, a cotton gauze or a cotton pad or a cotton ball, that they might all be used interchangeably?
We don't even have gauzes. This isn't mine. That's why I can't really tell you, because I've never seen it. And when she showed it to me, I still till this day, this isn't ours. So I don't know. I don't even know what that thing behind it is. I've never seen this before, ever. But from what it looks like to me, and we've pretty much researched it, it looks like a gauze, but I don't carry gauzes within my salon.
And then you've brought with you today exhibits of the pellon.
Correct.
Or muslin.
Correct.
And so, Jen, it was your testimony that the pellon is what's used because it tends to be not as absorbent as the photograph in number 3.
Correct. Because what that looked like was like an oil stain. It looked like if oil had fallen on it and it absorbed, and it was part of this. And this is the same one. Obviously that one piece was cut off, but this is the same one. If you see, there's still like a little bit of dirt because it was tossed in the bottom on the back. When I bought it at the hair show and I used it, I didn't like it. So I made sure that we never use this kind again. I don't even use it for my personal use, because once I apply and I try to wax off, it gets stuck. So I don't use it. But yes, what we use is this cloth one.
Okay. And how do you store the pellon?
It's in a closed cabinet. It's up in a closed cabinet, so whenever they use it, they just cut it, but it doesn't just sit outside like this. It's actually in a cabinet. in the room. It's always been, it could get dirty or contaminated if it's just sitting outside like this. So we always put it inside a closed. Sometimes we'll cut a bunch of pieces and we'll put it inside a little container like this where they're already pre-cut to use.
You also testified that you had gone out of the country, and that was kind of the reason for this kind of unsettling matter in the first place. And I just wanted to ask you, is that the excuse for the violation of the law, that you were out of town?
No, sir, there's no excuse. Unfortunately, I wasn't there to supervise any of this. And if I'd been there, this would not happen. I've been in communication quite a bit with State Board. They've came in, done investigations, and they see I don't run the salon like this when I'm there. Unfortunately, when you get too busy, you do have somebody manage it. It's fair to have a managing role there. And the lady that was supposed to buy my salon has experience, to my knowledge, for years because she owned her own salon in her country. So the ideas and the business plan that she brought to me was perfect. And I felt that I could trust this person in question. Unfortunately, that wasn't the case. And I left, and I think not even a day or two later, they called State Board to say that there's unlicensed workers there. Now, there was another lady that was going to buy the salon before her, was upset. She left, gone. It was a big soap opera. It was a huge soap opera. It was horrible. So when this happened, I said, it was like a plot, obviously. Landlord had already been contacted prior to this happening. If Connie were to leave, would you rent it out to us? They had already been, in contact. So luckily I have great communication with my landlord, and he allowed me to stay, and he saw what was going on. He saw the injustice of it, and he even gave me half of the salon. I did the build out, and he allowed me to keep half of the salon.
You heard earlier that that Mr. Taylor was concerned that maybe cost savings was inadvertently maybe have been mentioned as a factual allegation or not. When you purchase supplies, do you at all pay attention to the cost of your supplies?
Not really, no. I don't really.
Rampant spending?
Yeah, especially at that time, I had money, a lot of money. So there's no, no, we have extras. And at my house, I have extras. Because when I go to hair shows, I really stock up. I really, really, really do stock up. I buy the latest of everything that's out there. 2, 3.
Cost is really not a subject matter for your supply purchase decisions.
No, they have more than enough to choose from as far as waxing types. Another reason why we had tossed also the pot is because I already had new pots. You know what I mean? I still have new pots. They're in storage. They're down in my salon right now. If you were to see, we have tons of waxing equipment. So I don't feel that was the actual reason that we're trying to save. She did mention perhaps laziness, but this isn't ours, and neither is that box. And you reusing a strip on someone else that has been waxed, that's disgusting. I don't see it. And I don't even think a client would want to be, they see everything. We've done a lot of changes, even from manicure pedicures. We now sanitize. We put everything in a little plastic container. You rip off. It's brand new. Every file buffer they get to take home if they want it. We don't reuse anything. It's brand new. The only thing we do is sanitize our tools with barbicide, and then also in a sanitizer.
Appropriate to the manufacturer's instructions.
Correct. Okay. Exactly. And I even tossed out the old bowls that had jets. We no longer have jets. We've made a tremendous change. I like to say, and I'm very proud to say, won the Best of Las Vegas 2012 in Las Vegas. That's a huge accomplishment for me. We're first page on Google because of all the marketing that I do. For being in Las Vegas, you could find us first page. If you're in Canada and China, anywhere around the world, I need to be up to par with the State Board regulations. That's why I'm telling you, this is not mine. This is not mine, but unfortunately, I'm here, and fortunately I'm here, and I'm trying to make things right. And fortunately, I left my business in the hands of somebody for a few days, and it all fell apart. But that's no longer going to happen.
Any other questions of Ms. Pena or Mr. Taylor?
I have one question.
Please, Ms. Booth.
What happened to the lady that was in charge? Where is she at in this scenario?
No one is, we closed and I had to hire new staff. About 2 months later, I reopened.
Okay. So she was terminated or she just left?
Everybody left. We were closed. When Miss Fitzgerald came that day, we shut the salon and nobody wanted to come back. Don't blame them.
Okay. Thank you.
Mr. Nixdorf, any final question from the north?
No, I'm good. Thank you.
And I do have a follow-up when you're ready.
When you're ready, Mr. Taylor, now is a good opportunity.
Thank you. Ms. Pena, for all the talk about Ms. Crawford, the person who was managing the business or whatever that you were involved in, Barbara Hill was the cosmetologist you left in charge. Is that correct?
That's correct.
And if Barbara Hill had walked into that waxing room and seen these conditions, Barbara Hill should have acted. Isn't that correct?
That's correct.
And if Barbara Hill was aware that there were unlicensed individuals practicing cosmetology in Mia Bella Salon, she had a responsibility to take action on that, did she not?
Absolutely. I mean, she's a cosmetologist. She took the exam, the test, everything, the schooling. I mean, I even have a license. It's just not here. But yes, yeah.
I'm talking about what she knows.
Yes, that's correct.
I'm talking about, did you leave her responsible for those duties to make sure the cosmetology laws and regulations were in fact going to be complied with at that salon?
Yes.
Okay. And if she somehow felt intimidated or overwhelmed by Ms. Crawford, she should have called you. Isn't that correct?
Yes, yes.
And you would have taken action. Isn't that correct?
Yes.
All right.
Are you completed with your questioning, Mr. Taylor, or you
I
have
am.
another?
I am. Lawyers
Feels
can keep
good.
going on forever, but I'm in fact through.
Yeah, we were hoping. Any?
That's fair.
And so at this time, Ms. Bradley, did you have any cross questions or cross-exam questions?
No, I have no questions.
Redirects. Any board members have any additional questions or concerns of any of the parties sitting before you? At this time, I'd like to take the opportunity to ask if anyone has a motion regarding whether or not, closing statements, right. Closing statements. Ms. Bradley.
Thank you. I would submit to the board that based on the testimony you've heard today from both Ms. Fitzgerald as well as Ms. Pena, that the allegations in the complaint have been proven. The establishment, there was an anonymous complaint received. Ms. Fitzgerald testified to that. She went in and did an inspection, and she told you what she saw in the inspection, which was that stained and used cotton balls, waxing strips, and what appeared to be blood on a piece of cotton inside a closed container. She testified that she took pictures. Those pictures of what she saw are Exhibit 4, and she said that those are exactly what she saw on that day and that she took those pictures and that those are true and accurate pictures of what she saw. So regardless of where it came from, where it didn't come from, it was in the salon. That's her testimony, and her testimony is she took those pictures. And so based on that, we believe that the factual allegation has been proven. Also, if we look at, there was unlicensed activities going on as well, and as noted in here, citations were issued. And there was talk about cost saving or time saving. I mean, maybe, Ms. Fitzgerald said laziness. Well, that's time saving, perhaps. That's, not wanting to take the time it takes. So maybe it's not cost that's a primary factor, but it could be saving time, getting people in and out. And again, that may not be Ms. Pena's motivation, but certainly she's responsible as a salon owner for what happens in her salon, and she's responsible for what the people in her salon do. And so it's unfortunate that she was out of the country and perhaps left someone in charge that she should not have, but she's still responsible as a salon owner to make sure that the salon is sanitary and safe and all of the rules and regulations of the board are followed. So because as the board is aware, sanitation is so important. That's why we also have the allegations from 12 and 13 in the complaint. This is a fundamental part of the practice of cosmetology, the safetiness of the patrons as well as the people that are actually applying the materials so that it's safe for everyone involved. And again, it's the law. And so we would submit that those have also been proven. So we would ask that the board find that the factual allegations and the violations of law have been proven and that the board determine an appropriate penalty for that violation. Thank you.
Mr. Taylor, now is an opportunity for you to provide some closing statements.
Thank you. Let me first of all apologize. We couldn't have this hearing earlier today because I had 2 other hearings to be at, so the delay in getting this hearing started was entirely on me. Ultimately, what licensing boards can do when they are given examples of serious violations of the statutes and regulations, what licensing boards at that point can do is look ahead, look down the road. Licensing boards are in the business of protecting public health, safety, and welfare. Clearly, if the what the inspector saw on that day were going to go on in the future in a salon owned by Connie Pena, then the board would have very serious reasons to wonder whether or not that person should be allowed anywhere near a salon or not. I had to ask some of the questions I did because of the language which was in the complaint. I hope you understand that's what lawyers do. But what I really, and however Ms. Pena feels or their conspiracies or whatever, bottom line, the question is, if an inspector goes into Mia Bella tomorrow, will they find violations? If someone goes into Mia Bella in 6 weeks, will they find violations? If they go in 6 months, will they find violations? Will the public, in fact, be put at risk? If the board takes into account the statements by Ms. Pena with regards to the way she thought while she was gone the salon was operating, and that she had, in fact, had put the salon, she may have inadvertently put somebody in a power position that she shouldn't have as we look back on it, but certainly had left a cosmetologist there who should know what the law is and should have taken action if she was aware of any of the violations that have been alleged in this case. What I'm suggesting to you is really an argument in mitigation. I don't know who walked this box in there. I can't take it out of the room. I don't know how, I could make clever arguments all day long about how this strip was there, and we can say, look, these are not the strips but that they normally use there, but somebody apparently walked in there and put that strip there, and somebody who was unlicensed, 2 people who were unlicensed, were in that shop on that day when the investigator was there. By the way, we have no excuse for the lapsed license, none. All right, it's one of the things that scares me with my licenses every year. But that having been said, and given what has happened since January of this year, I would hope if the board finds the violations have been proven, that the board would take into account the dedication which has been shown by Ms. Pena at this point to ensure that like violations and like potential harm to the public will not in fact occur at Mia Bella at any time in the future, and just take that into consideration. I would hope that whatever penalty might be given will acknowledge her taking up responsibility for the future of Mia Bella. Thank you.
Thank you. Very compelling. Any final comments, questions, discussion by the board? I'd like to take an opportunity to ask for a motion on whether or not the factual allegations 1 through 16 have been proven.
I'll make a motion that the facts 1 through 16 have been found to have been proven.
I'll second.
There's a motion and a second. Is there any question, comment, or discussion? All those in favor, please say aye.
Aye. Aye.
Any opposed? Any opposed? That motion carries. In terms of the violations of the law, there are 3 claims of relief. Would anyone like to propose a motion that the violations of the law have been proven?
I'd like to make a motion that the violations of the law have been proven and would like to assess a fine of $200 for each.
Not just quite yet.
Oh, we can't, I thought we had to do that now.
The violations will be first.
Okay.
And then the disciplinary action will follow. There's a motion on the table with some clarification of that motion. And is there a second? Is there a second?
I'll second
I'll
that
second.
motion.
Okay, Mr. Hoffman is the second. Is there a question or comments or discussion regarding the violations of the law? All those in favor, please say aye.
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 Is there any opposed? And that motion carries. And Ms. Booth, now is the opportunity to...
Actually, staff has a recommendation
Okay.
in this case.
So Ms. Booth, if you'll pay close attention to Ms. Bradley's recommendation.
So staff would recommend a fine of $1,000 for each claim for relief, for a total of $3,000. And then staff also recommends that the licensee reimburse the board for its costs in this matter not to exceed $750 with an exact amount to be provided. And that would be my time, and I can prepare that report and send that to them so they know exactly how much money they need to pay. So that would be staff's recommendation based on the facts of this case.
Is there any question? Mr. Nixdorf, just to double check with you first.
I do
if there's
have a
any
question
or comment.
I do have a question on how
Please.
that matter, how the dollar amount was ascertained.
Mr. Landry may be able to speak to that, and then I think Mr. Taylor may want to comment on staff recommendation. Normally, we allow them to comment on a recommendation before the board decides.
Yeah, staff recommendation is based on the severity of the what was found there, and was corroborated by both Ms. Pena and her attorney saying, under many times that no one should ever operate a salon that way. That no one should ever go into a salon that looks like that, and that it was a very unsafe area. So these recommendations were made prior to the respondent's attorney's plea, stating why he thinks that this won't happen again. But that was based on the $1,000 came up relative to other cases that we've had that would have similar problems in the salon with sanitation.
Mr. Landry, we had 2 unlicensed people in there. Those would be $1,000 fines by themselves. Were those fines paid separately, or were they not paid? How does that figure into this?
That's not relevant to this case. I don't know the exact status of those, but it's not relevant to this case. This case is for the salon, not for the unlicensed activity.
Okay, thank you.
Any other questions or comments or concerns?
And I would have one comment when you're ready.
Yes, Mr. Taylor.
Yeah,
Please.
I'm not going to redo my closing argument, but to the degree that fines are for the purpose of ensuring that bad behavior doesn't happen again, I would suggest that in this case, the owner of Mia Bella has in fact put in quite a bit of money into literally restructuring this entire salon to make it a better place for the public to receive services. I would hope that rather than $1,000, that the board would consider $500 per count, assuming that they've already found per claim, plus the cost as alleged, and that if necessary, that they allow the owner to make some sort of payment plan. I do think that's all that's really necessary to emphasize the seriousness at this point.
Ms. Pena, do you carry an establishment license now?
Oh,
currently?
yes, I do.
And do you know the renewal date of your current establishment?
August 2015.
August of 2015.
Yes.
So nine.
And then also as a point of clarification, you stated how long the salon was closed from the incident to when you reopened?
6 weeks almost.
Okay, so at least a month, but more like a month and a half.
Yeah, it was a little bit more. It took me a while to staff it. So I only had one person working in 2 days out of the week until almost 3 months. I was able to open it completely.
Okay.
And I had to get a new sign.
So between a month and a half and 90 days to reestablish, reopen, and start to
Oh, yeah. To
create
start to
revenue from
actually.
your business. Got it.
Exactly.
Okay. Thank you.
Any other questions or comments or concerns? We've all heard Mr. Taylor's compelling argument. We've all heard Ms. Bradley's recommendation. Mr. Nixdorf, I'll defer to you one last time for any questions or comments or discussion.
No further questions.
Or if you'd like to, and would you like to propose any motion, or would anyone?
I believe Ms. Booth was.
Please, Ms. Booth.
I'd like to propose a motion that for each violation of $500. That was what I had in my mind to begin with, because it is the second offense. So it would be $500 for all three, for each of the violations.
And then what about costs?
Oh, I'm sorry, and attorney's fees.
And it was the recommendation of staff that attorney's fees not exceed $750.
And I'll add that to my motion, that the fees not to exceed $750.
And so for clarification, it was $500 for each claim of relief with a total of $1,500?
Correct.
And costs not to exceed $750?
Correct.
And then just as a formal clarification, those would have to be paid within roughly 9 months at the time of renewal.
That is correct.
So the payment plan would be roughly 8 some odd months. Is that right?
Correct.
And is there a second to that motion? Would anyone like to second that motion? Absent a second, that motion dies.
I can't say nothing. Sorry.
Oh,
was that?
I'd take the opportunity.
No.
No, I'm sorry. So at this time, since that motion failed, I'd be more than happy to entertain a second motion. A second motion. Discussion. Any discussion on why someone was not seconding that motion? What's the rationale? Who didn't like it?
I think it's a gross malpractice, personally. It's gross malpractice to own and operate a facility. If you owned a restaurant and you were out of the country and people got poisoned, you hold it. You own a salon, you don't know the law, that's your bad. You're supposed to know the law. So you're having somebody run and operate your store. You still take the hit for that. That's your responsibility. Now you're running a salon again. I don't see it. I think $1,000 per violation is fair. I think it's a cavalier and gross malpractice in my opinion.
Any other comments?
Yeah, I don't think that this rises to that level. I mean, what we've got here is some cotton pads and some tweezers. We got a little waxing issue here where somebody didn't throw their stuff away. I don't know that necessarily rises to such a huge fine. You know, I'm not. I mean, it's not like we have a constant, consistent, repetitive situation here. This is a one-shot deal. She goes out of town. Somebody that she trusts betrays her trusts, and nobody was hurt in this issue. It was, I don't know. I don't think that this is all that big of a. I mean, it's a violation.
Did you see the
clearly.
wax spot?
Yeah, I've seen the wax spot. I've seen, you know.
Do you think that looks like 3 days worth of buildup there?
No, but you know, I could
3
put
days?
it. You could put a collar over that. This wax spot could have come in from somewhere else. You know,
Mr. Nixdorf, propose?
Yeah, you know, I'm not comfortable with making a huge fine out of this personally. So anyway, that's my
Mr.
point of view.
Nixdorf, would you like to propose a motion with a disciplinary fine appropriate to your thought process?
Sure. Let's see. I suggest that we fine her. Actually, I do have one other one. I got a question. It's just now bothering me here a little bit here. In the allegations that we found to be true, this will. It says here that under factual allegation number 8, that her included an unlicensed person that was performing a nail service on a client. That rises to me to the having an unlicensed thing, and and Mr. Landry was saying that's not part of this, but here it is part of that. So my suggestion would be to impose the fine of unlicensed activity of $1,000 each for the unlicensed activity, and $200.
Well, Mr. Nixdorf, I appreciate where you're going with that, but actually that doesn't really work for today. The factual allegation number 8 has already been proven. That
Correct.
was voted on unanimously.
So why aren't we fining
the
for it?
violations? Yeah, but the violations of the law, there's 3, and those have already been again voted as being proven. And so
I'm not disputing that. What I am saying is the justification for the dollar amount of the fines, I don't think should be necessarily penal in nature, that this is such a huge, egregious problem with poor sanitation. But I think that the total amount of the fine should include the fines for the unlicensed activity. And so my suggestion is that the total amount for all 3 of them should include $1,000 each for the unlicensed activity and $200 apiece for the. So I'm looking at $2,600 total fine. Is how I would.
Mr. Nixdorf.
So anyway,
I'm going to let Ms. Arguella speak to that.
Yes.
I can tell she has something to say.
Okay.
The unlicensed activity is not a part of this complaint. It is not part of the findings. The violations of law do not include a violation for unlicensed activity. I believe that's been dealt with in a separate case. You cannot take that into consideration when you are applying or dispensing discipline for these particular violations, and that's all we're talking about. This is what they had notice of. This is what we were here talking about. So these particular violations of law are what need to be considered when determining how much discipline you're going to impose. So that other issue, while it is important because it was in the factual allegations, it laid context to what occurred at the salon that gave rise to these particular violations. But it is these particular violations that you are here to consider.
Right, and those violations include, it says other violations were noted, and that included unlicensed person was performing a nail service. So to me, it's included in these factual allegations.
Yeah, but at that time, that person was issued a citation, and then that's a whole separate case. We're just here for the 3 claims of relief and what we're going to fine her for those. That's all.
Absolutely. We don't want to add in additional things that are not part of these particular violations of law.
And if I may, I am helping the board locate Ms. Crawford for you guys to be able to pursue that fine. That's why I wanted to respectfully request originally what Ms. Booth had said, $200 minimum fine due to all the investment that I've already made to remodel the salon, to make all the changes. But I am more than happy to help you guys locate one of the unlicensee that day.
We're at the deliberation of the board, so please don't testify anymore.
I'd like to know how that was handled. Has it been gone to court? Have we processed that?
That's
That's not part of what we're
purview today.
Yeah,
We
we're not
can't
here
ask
to
about it?
discuss that. No, what you are here to do is look at this particular complaint, look at the violations, and fine her with regard to these violations only.
So I propose a motion that for each claim of relief, the fine of $200 be assessed, and I'm not convinced that the costs. We've had a very cooperative situation occur in front of us with full faith at being the best in compliance with the board. So that's my motion.
Thank you.
I'll second that motion.
There is a motion and a second for $200 for each claim of relief in the violations of law that have been proven, for a total of $600. Costs would then be zero, if I heard you correctly. Again,
Correct.
The payment terms would be payable prior to renewal. Any questions or comments or discussion? Mr. Nixdorf, I'll defer to you first.
I'm good.
Okay, and you understood and heard the motion?
I did.
Any other question or comment or discussion? All those in favor, please say aye.
Aye.
Aye. All those opposed?
Nay.
Nay.
Will you raise your hand on the 2 nays? Thank you. And that motion carries. Ms. Pena, Ms. Bradley will prepare an order for you, and that will detail,
Yes, sir.
or pardon me, that will detail the events of today and the findings, and it will give you the opportunity to pay that fine prior to license renewal.
Thank you. Thank you
Okay.
very much. Thank you.
Mr. Taylor, thank you for your comments today and your compelling argument and on behalf of your client.
Thank you.
That moves us into our, oh, I'm sorry, please. Yes, most definitely. That was a long matter. We're going to take a 5-minute recess. The time for it's now 3:20, and we will resume at 3:30.
Great to see you. Janet, come in. Come here. Let me shake your hand. My girl.
So you guys about ready? All right, so it's 3:33. It's about ready to reconvene. I don't think they can hear me. They're sure doing a good job of ignoring me.
We're all set, Mr. Nixon.
All right. All right, so it's now 3:33. I'm going to reconvene this meeting. All right, so we're going to go to item number 20, consideration and approval of Executive Director's Report. So, Mr. Landry, the floor is yours.
In the spirit of brevity, the Executive Director's Report gives all the information that we normally give, with 2 or 3 notable exceptions. One is we did a cash flow summary, as was requested at the last board meeting. So you can see what the cash flow is minus, taking out all the depreciation amounts. And just so you know, in summary, the day that I started versus today versus the projection for 2015, which is where we carried it all the way out to the end of this fiscal year, we are up between $250,000 and $300,000 in net assets, and that's after spending all the dollars we had to spend on upgrading monitors, upgrading computers, upgrading the network, upgrading the phones, and upgrading our back office system. So all of that, and we are still, because there were some concerns or questions about the net assets that we were accumulating. We've yet to touch any of our CDs that we've ever put aside, and we're working on from the cash flow that we generate on a monthly basis. So we're solvent, we're solid, and I just wanted to make mention of that because that was a discussion. Another thing you're going to see in this Executive Director's Report that you don't normally see, because it only happens once a year, is the audit report and summary. And the takeaways from that, most notably, the things that they called out that we were deficient in were all pointed at our difficulties in using the Versa system. We are no exactly, and so that's been eliminated. You will not be seeing those same comments when you look at next year's report. Mostly it was just at a high level, the cash balance on a monthly basis always tied out. But because of the recording difficulties in Versa and how they record cash, the daily balances didn't always tie out. So we always tied out for the week, we always tied out for the month, but on a daily basis. And if you don't tie it on a daily basis, that is something that an auditor gets nervous about. They will make mention and comment on that. So that particular piece of it's going to go away. The other update that I did is on the strategic plan update. I did put in red any of the changes as per Ms. Booth's request, so that so all board members can now see those things that have changed versus those things that are just repetitious. So those are the
I'd like to say thank you very much, because it makes for much easier reading that way, and I don't have to go back and forth. So thank you very much.
No problem. And so just from a point of brevity, I'll answer any question that any of the board members have, but that's kind of what was different about this report than previous reports.
Could I have from you?
Go ahead, Koki.
I see your daily, your weekly reports on the GL Solutions. Could you give us kind of a verbal, because I'm sure the members that are here would like it, and I'd like to know, because I see there's some hiccups. Were those fixed? So if we could have just kind of a update on the program.
I'd be glad to. The GL Solutions we went live last week on a short work week since we had a holiday work week. And I had prepared staff to let them know that it was probably going to be the worst week of their life working for the board. And fortunately, it was not. So it was not as big a deal but we wanted to make sure everyone was prepared that there could be some hiccups and glitches, because no matter how much you test a system, when you go live with real data and are doing things on a daily basis, things can get, you can have problems. It was not flawless. There were errors and there were problems. There was nothing critical that went wrong at conversion. And as of the end of the week, we had pretty much caught up with all of the processing that we had to do. Just so the board knows, we stopped processing in Versa the Wednesday before we did conversion. So we had Wednesday, Thursday, Friday, Saturday, Sunday to catch up on in a 3-day work week, the Monday, Tuesday, Wednesday time frame. And the staff, I do want to congratulate staff. They did yeoman's work in getting all the stuff done, getting everything up to speed, and we did not have any noticeable delays on issuing licenses or taking tests. And those are the two critical areas that we want to focus on, is making sure that our students could still test and that we could still issue licenses. So that's at a high level. There's a whole list of things that have been corrected and are going to be corrected. We're in a 3-month stabilization phase, and so over the next 3 months there will be little things that will be tweaked on a daily basis to get everything just right.
Could you give me the highlight of what are the major things this is going to do for us?
Sure. The biggest thing that it's going to do for us is that we're working with a partner that is willing to change the application. Our previous work and my first couple of estimates that I got from the Iron Data people, the people who support and operate Versa, was not very budget friendly. It was going to be very expensive to do anything that we wanted to do to get things moving in the right direction. In contrast, we have an all-in-one price. We didn't pay anything up front. We pay by the month. The monthly fee includes all support, includes all updates, and it includes all modifications and transitions and changes. So we have seven projects this year that we're going to be able to do and make modifications and improvements. The two first biggest ones that we're going to do is online renewals of licenses. You should see that in about a 60-day time frame. And that's going to be, the staff's going to really love that, because that takes us off of I was going to pay it, but you were closed. I was going to pay it, but I couldn't get to couldn't get a money order. By doing online renewals, you'll be able to do it at 24 hours a day, 7 days a week, and do it with a credit card. So that's going to probably be the first biggest thing. The next biggest thing that we're going to do is even with the new GL Solution system, Versa on a renewal, I think was something like 60 or 70 keystrokes to get it done, or clicks to get it done. The GL Solutions is about 34, 35 clicks that you have to do to get a renewal done. We want to get that down to about 5 to 10. So really increase the efficiency of the staff. Those are the things that we get out of the new system, and the fact that we're not in the software business anymore. It's hosted remotely. We don't have to worry about backing data up. That's backed up for us. And we have access to it through a browser. So if anything happened to our headquarters, we could operate doing testing, licensing, and inspections from anywhere that has a computer with a browser, from Starbucks, actually.
I just have a quick question, Gary, about the licensing when we do it online. And how do we get our pictures in there, or do we get a receipt? The pictures come. I mean, how do we verify that that's their license?
Yeah, the way that it'll work, you will be uploading a JPEG. Typically it'll be either there are applications that you can use on smartphones that you can actually take your own picture and have it cropped to the right size. You can also scan in for those that that have scanners and want to do it from a technology standpoint. But it's basically a simple upload feature. We always compare the picture that's uploaded with the previous picture to make sure it's the same person that's doing the renewal. But we'll have security where the licensee will have their own user ID and password to log into their account. So that's one of the areas. And we're not unique or first in this area. We're probably one of the last cosmetology boards in the United States that's doing online renewals. But the good news is that the GL Solutions does it for a lot of other cosmetology boards, as well as driver's license bureaus. They do doctors, lawyers, engineers. Their specialty is kind of our size, although they do, I think their biggest client has 3 million licensees. They do, I can't remember if it's Montana or Wyoming, their driver's licenses. So, I mean, they have the scalability to grow with us. We're not going to outgrow their system, but it's been a real good experience working with them thus far. It's not perfect. No software company is ever perfect, but they're at least a company we can work with.
I think that's a great advantage with the software, that you don't have to pay up front for it and that it is a monthly fee. I think that's a new trend, and it's very cost effective that way. So, and with a lot of new things for the members, so I think that's great. Thank you, Gary.
Mr. Leader, you usually have a few questions.
I did, Mr. Nixdorf. I was trying to figure out how much of it we were able to talk about at one time. Mr. Landry, I wanted to just double check on a couple of observations that I had. When we looked at the testing summary, I was noticing, well, first of all, my observation is that the esthetician theory exams we have a very low failure rate for aesthetics. So I wanted to shout out to all you estheticians who pass on the first round of that test. Thank you and congratulations. But oddly enough, there was an anomaly in February of, almost nearly a third of that theory failed that exam. Can you speak to that anomaly at all? Do you see that? Yeah.
I can't speak to that. This is I don't remember the exact occurrence of what happened in February. Typically, it's the same test that's being given the same way. It's proctored the same. We're very uniform because the theory test is done by computer. So it should, we give instructions to the students. They sit down and take it, whatever is going on at that time. I agree that, there's nine estheticians failing. It is the highest number that failed out of any of the months for the entire year, I believe.
For the whole year, yeah. And then even in the total, it's reflected in the total.
Yeah, so that's, I can't explain it, but that's, it is what it is. It's, whoever was taking the test at that time.
And I noticed that you have just two categories. You have a passed and you have a failed. But we really don't know the retakes on this particular summary. So when we look at the figures, I'm looking at now the year-to-date summary, this number right here, and that's a third of the folks taking the test are failing.
Not necessarily, because the people that do the retake, if you look at the mathematics of it, the failed includes not only first failures, but could be a second failure also. So there's a lot more in that. And when you look at the total failed, it also includes reciprocity candidates who would fail the law test, which is the most failed exam that we have, if you look at the numbers.
And so then I'm going to direct a comment to Mr. Helms is, how are we assessing the fiscal impact of the reduction in the retake fees? Because currently right now I can kind of do the math because it's a 110 across the board. But as soon as I see that 1,000 failures, I'm not able to do the math because the fee will now be reduced.
Andrew Helms, Chief Financial Officer. I believe Gary actually put together a nice spreadsheet in another part of
Do you have it?
The agenda. I saw it earlier. I'm just trying to recall where it was. It actually shows the fiscal impact.
I saw that also, but I mean on the summary reports. Like right now, the summary report isn't giving me the opportunity to just visually calculate $110 for each passing. And I don't have to worry about it yet, right? The $75.
You don't actually have to worry about it at all, because one of the things that we're doing is we're converting the law test to be, instead of being executed by PSI, we're actually going to use the law test with a program we use now for the sanitation test, called Brainshark, and that's a flat fee. So for no increase in cost, we're going to be able to do the retakes through Brainshark. And so instead of there being a $50 cost per test, it will be a $0 cost per test. So we'll actually be making more money as we go forward. And there's an opportunity for people that would normally maybe have not taken the test. They just could have given up and decide to go some other career path. It'll allow them to possibly take another, take another shot at it. We're also, we've been very successful on people who have had multiple failures for the law test, to work with them through a course that Mr. Green, one of our inspectors, has put together. And we've had a very high pass rate on getting the licensees to pass after he's had some kind of not one-on-one, but a classroom type instruction as a refresher.
So, Mr. Helms, really the fiscal impact is actually in the positive.
Correct.
Even though the retake fee will be less.
Exactly.
And so is there a way to form the spreadsheet to reflect that?
I mean,
the cash flow statement or just the testing summary?
The testing summary I'd like to keep as pure as possible because it is about numbers of passing and failing. The financial impact of it, I mean, we could certainly create another report that would have the cost of testing versus the revenue that we get from that. I mean, that's not a very difficult thing if there's some benefit to doing that.
Does anybody else see a benefit to that, or do you just see that as being a waste of time? I mean, because it's,
how much more salary time usage of that is there to show us what we're saving in money? I guess would be my question. Is it necessary to expend more man hours for just one test?
No,
not one test, one summary of the tests.
It does. I mean, anything that we do net new, but I mean, it will be it would be a matter of accounting for the retakes as a separate item rather than just total failed. So it's breaking out that number. I mean, it's not a huge task for us to do. Just if it would provide some benefit. And I think
the only reason why I'm asking is because when you look at that total failed of 1,200 people, it's not $110. I mean, it is right now.
Right.
But in the future, it won't be. And so it's kind of just challenging to...
Well, one thing I could do in the future is I could account for those retakes in a separate account. So currently I just have one general ledger exam account. So what I could do is just put all the retakes in a different account, and that way it'd be a lot easier to draw on that information and then corroborate it into an actual report.
Plus, you'd see the income.
Correct.
Because it's an income generator
just
now.
from the retakes, which is easy to do on my end.
I mean, do we ask for that? Or is that something that you would direct somebody to do that?
Yeah. I mean, if you want to see that, and just so you know, under agenda item number 7 is where the revenue impact for retake fees is done. And that's where I took all of the, what we do for cosmetology law, theory, practical, the retakes for law, the retakes for theory, retakes for practical, and these are based on run rates that we're currently experiencing. And I show that the net positive impact, the increased licensing revenue, would actually be about $110,000 based on the fact that we moved to Brainshark and we lower the fee to $75. So the combination of those two would be a net $110,000 positive to the bottom line for the agency.
Okay, yeah, that would make more sense for me.
Okay.
Yeah.
Mr. Leader, do you have other questions?
Just a quick few. Again, just kudos to aesthetics, because statistically our failure rate is dramatically less than any other licensing category. And if I'm not mistaken, when I look at the testing summaries, statistically the failure rate is much lower for aesthetics.
So are you directing me to get with?
Did you have a question for Mr. Leader?
It was an observation. Mr. Landry? It was just an observation is all. I also wanted to take a look at this inspection summary.
Okay.
And the citations, it lists inspections and citations for North and South throughout for each month. And my concern is with citations, aren't we talking about 3 separate categories of citations: civil, establishment, and then individual licensing? And I'm wondering if there would be some benefit to know the breakdown of the citations.
if you see there's a benefit, we can report it. I don't know that there's a benefit. I mean, I don't know if it makes you take any action differently than you would otherwise without that information.
Well, it just seems to me like even today we had concerns that an establishment was being penalized, but nobody knew whether a civil citation had been issued.
That's an entirely different issue. The one thing that you can't do, just so you know, if it's being penalized and if there's evidence or action that was taken outside of the actual case, Sarah could probably correct me, but I don't think you can bring that up. That's not a relevant point in the case.
No, you can only make your decision based on the facts that are before you. And in that case, it said 2 other citations were issued for the unlicensed activity. So it told you that was noted as context, as Ms. Arguello said, and then it said that 2 citations were issued. So that was the information that you had, and that was all you were permitted to have in that case. And normally speaking, that's true. 233B.126 requires that you make your decision in all contested cases and hearings based on the information you have. So whether other citations were issued or not issued, you decide based on what it is. Now, you might say to staff, I hope another citation was issued in this case because that would be important, and then maybe staff knows. I think they already do, but I mean, you can certainly let your wishes be known, I suppose, but your decision is based solely on what's before you.
So would any other board member benefit from a breakdown of the citations highlighting whether they were a civil, which is unlicensed activity, establishment or individual citation?
I'd like to see it, providing it doesn't take a lot of work to do it. Is that something that can be simply done? Or will it take, if it's going to take a lot of manpower and dollars to get that done?
I can just change. We do it all by spreadsheet accumulation. So, and we do it on a daily basis. So all it is I'll need to rework the spreadsheet, which is a one-time thing, and then instead of putting in a citation, they'll just put the type of citation it is.
I think it'd be helpful, Mr. Linder, I do. Maybe we could go back if it doesn't seem to be doing any good, but initially I think it'd be quite helpful. On the consequently on the, Annie, pardon me.
Actually, on the, when you're putting them in the charting, according to the law, or the 360.2 is the unlicensed activity, and 190.2 NRS 644. It's easy to separate it out. It's all there.
Right.
But it could just be another category added.
I think it just might be, it would make the summary for me a little more explanatory. And again, taking a look at the next couple pages, the actual versus estimated cash flow analysis. Again, why are there spikes in that income, and it's seemingly every May?
That would be the leftover from the renewals that used to be, all salons used to renew on the same day, and then it was converted to the day that they actually got their initial license. So you're seeing residual. Every 2 years, you're going to see a spike on that particular day, because those are the salons that were licensed and didn't relicense new. So it's over time it'll spread out, but for now we do an awful lot of salon renewals in one particular month on one particular day.
Right. Okay.
And it occurs there. That's why you see it's a 2-year cycle.
In the audit report, I guess from Holdsworth, I just wanted to double check. There were some material adjustments to the financial statements. There were also the Versa access control profiles, the override and edit functions. And then there were the revenue receipts logs and also the deferred revenue schedules. You know, we've seen these recommended changes to the audit for several years now. So
I can speak to most of those points. In particular, the material adjustments, that was merely just my own doing. Basically, what's that saying? This refers to adjustments that need to occur to the financial statements at year end. Basically, in accounting, you have the matching principle. So you match the actual expenses to the month that it occurred rather than when the actual cash went out. And that was simply making those adjustments. That way we captured those accounts payable invoices in June rather than July. So that's what the majority of those material adjustments were. As far as the Versa access control profiles, that second point, With GL Solutions, one of the main things is that we'll have much tighter security over all the employee accounts. So a lot of that separation of controls that you hear about in accounting, that will be very well established and in place. The revenue receipts log, I think we're going to clear that up with the new Konica Minolta software called DocRec, which is essentially scanning software where we'll have an incoming piece of mail. You can scan it in, and in a sense, that'll create a log as well as a backup scan copy of all the incoming mail.
And the two people would open that mail together?
We haven't actually established how we're going to do that right now. Right now,
so that was a recommendation last year also.
Yes, it was.
And I think it's an overkill,
okay.
to be quite honest, because the amount of mail we get and the amount of mail we're going to be getting as we move forward, where we have online renewals, is going to be a dwindling number. So there are things that I agree with the auditors, which is most everything that they pointed out, but having to pay two people to sit and open mail, that seems a bit of overkill for our agency, which has never had one, since Debbie's been here and now all through Andrew, we've never had one question of any number that's ever been put on any of our financial statements.
Okay.
And I'd like to say, too,
there's still one more.
I just want to say, too, I think if it's overkill, too, I have to agree with that, because whoever is opening the mail, and if they took somebody's money, they would be reporting that they didn't get their license. So it would be easy to find out that you had a problem. So I really feel that is overkill. I would agree with you on that.
And you're saying that it's not going to happen once you switch from Versa to GL anyway? So it shows up in this audit.
It will still show up, but the amount that's going to show up is going to dwindle, because as we go to 30%, 40%, 50% online renewals, that's a whole lot less mail that's coming in. So I mean, it's whatever the impact is today is its maximum. From this point forward, when we have online renewals, it's going to become less and less and less important. And like I said, I will debate the auditors on this, because I just don't see that as a practical matter that it needs to be done. To me, it's a waste of time.
And then how about that tracking of deferred revenue? That was in that deferred revenue schedule.
And again, this is going to be improved by our new system, GL Solutions, and also the way that we currently defer out the revenue. I hate to say it, but right now it's kind of convoluted. So we're going to change our system to where we're actually deferring based on a 6-month window on either side of the licensee's birthday. So that way we are not calculating out, I think it's 36 different months, and creating the difference there. So bottom line is the new system is going to make it a lot more accurate in terms of deferred revenue schedule too. That's probably one of the hardest accounting functions that I have to deal with.
Okay.
And one other thing that'll get cleared up in that same area is if the legislature approves all the suggested law changes, we will not be having a different license fee for every first-time initial licensee. Everyone will pay the same fee, whether you're getting a 1.5-year license or a 2.5-year license, a 3.5-year license or a 4.5-year license. That's the spread, depending on your birthday and what cycle the moon is in. I mean, it's a very convoluted system that we currently have. We're going to, if the legislature passes the law, it will be just like DMV. It's just bad luck if you were born and took a test on this date and were born on this date. You have a 1.5-year license. Someone else might have 1 year and 8 months. Someone else might have 2 years and 4 months. It's only the initial license. It'll only affect that, and from then on, everyone will be on either a 2 or 4-year license, their choice. So that's something that's going to help this also. And I agree with Andrew. I can't think of creating a monster like we've created on this on the accounting side for doing it to ourselves, because it did need to be done that way, but it was done, and that's it's water under the bridge. We're going to fix it, but it is if we don't get it fixed with the laws, you will see that same comment every year going forward, because it's to balance out a payment and spread it out over the 24 months of that license is not as easy as it sounds, because every day every day of the month is a different spread rate, and accumulating all that, when you've got 26,000 licensees, you will have small differences. And that's the auditor's job, to point out those small differences.
Okay. Thank you.
Any other questions, Mr.
Yeah.
Leader?
No. Anybody else?
I have,
Koki, could you turn on your mic?
I have one last question on the strategic plan. In here, you talk about customer feedback. I'm wondering if we could have a little report maybe done, what was their feedback, even if it's positive, but basically what was their feedback, and maybe have just a little, maybe they stated something in there and you made a correction on it, but just add into our policy here what the customer feedback was basically. And
What I can do is I can provide you a summary. Unfortunately, for privacy concerns, I can't reveal, because they're doing this.
fine, I don't want the whole thing, just a little summary would be perfect.
But I can tell you that we don't get a lot of customer feedback on the website in some of these surveys, but when we do, and we've probably gotten 15 or 20 different ones, the number one complaint is not enough information on the reciprocity process. So we're currently working on that. And this past week, I put together the state of Delaware has an excellent reciprocity flow chart and how, exactly how to go through the process. So we're going to model ours after theirs. But that's probably the number one complaint, is that when they look on the website, they can't figure out the reciprocity process because we don't lay it out very clear.
And I think that's important that we know that and that you're working on it so that the members also know that you're working on it. So if we could just maybe have a brief update thrown in here somewhere would be appreciated. Thank you.
All right.
And then I just had one last comment. It was on the executive director's report on the meeting follow-up. It was item number 13 where Ms. Howard, I had offered to assist Ms. Howard, and I just know that it says that staff has not received any updates. Ms. Howard and I met this morning prior to this meeting, and we are still working on assisting her with the status of her funding. And if you might recall Ms. Howard's comments at the last board meeting, they're similar.
All right, is that it? Anybody else? All right, so Mr. Landry, my question is more or less, I was wondering if you could give me a brief synopsis of the value of the strategic project that you've created in a method for us to monitor your progress and your abilities, and how that all ties in. I mean, this is clearly, it's a planning thing. It helps you do all kinds of stuff, and I was wondering if you could just help us use this to gauge your abilities.
I think one way that you could do that is tie some, either put numbers to it. It's very difficult to be evaluated when there are no hard numbers involved. So one of the things I think we could do is we could take each one of the strategic projects and look at forecasting either a completion date or a percentage uptake, like we have the online license renewal project. It's not good enough just to launch it, but you need to market it. You need to make sure that licensees understand how to use it. You need to take a very active, aggressive role on that if you want it to be successful. So I would think, one of the ways that you could utilize the strategic plan in doing the executive director's evaluation is take a variety of the different strategic initiatives and objectives, the strategic projects, and put either date deadlines or quantity deadlines to that. And I'd be willing to work, on what things would be, what I would think would be reasonable, what things the board would think would be reasonable for me to accomplish over the next year.
Thank you. And you already do that for yourself, do you not?
I mean, anytime there's a target, there's going to be a marker on it. I'm a numbers guy, so I like numbers. I don't like fuzzy stuff.
Perfect. Thank you very much. Okay. Any other comments or discussion about the executive director's report? All right, then we'll move on to number 18. Evaluate a proposal for the formation of a human resources subcommittee for the purpose of developing and reviewing proposed board policies.
Yeah.
All right.
No, Mr. Nixdorf, what I was going to say, to just interrupt you, don't we need to make a motion to accept or reject the executive director's report?
I suppose
it was listed for possible. Yeah, it was listed for possible
Usually
action.
you accept it, the consent agenda, or you don't. And so I know you're not really actually changing anything here, but.
Yeah, that's what we didn't make any changes. We were just clarified. It just was, I mean, if you feel comfortable making a proposal, a motion for that and us approving it, I'm okay with that too. So,
President, I'll make a motion that we approve the consent agenda and its contents.
And
I'll second.
Before you, it's not a consent agenda.
Correct.
It's actually the executive director's report, so you may have to modify your motion.
Right.
I'm sorry for jumping the gun to that, but I'll make a motion for the approval of the executive director's report. So it's no longer called a consent agenda?
No, we didn't do
Second.
yeah, this agenda didn't have a consent agenda. So who was that seconded?
It was a Koki Booth.
Okay. All right, so we have a motion and a second. Any discussion? All right, I'll call for a vote. All those in favor, say aye. Aye.
Aye.
Aye.
Any opposed? Okay, accepted. All right, so moving on to number 18. We're going to create a Human Resources Subcommittee. Koki has, and I are on that committee, or would like to be. I volunteered to chair that. And this is going to be reviewing proposed board policies concerning the hiring, evaluation, and termination of the executive director position. Koki and I have different points of view on what is right and what's wrong on this one, so we'd definitely appreciate somebody else volunteering to be a part of this committee to break and give us added input. So I'm looking for members to volunteer.
We haven't had a meeting yet, so I didn't know we were in disagreement.
Based on our discussions here, yeah. All right, so anyway, so I guess the first matter of business would be to create a motion that creates this Human Resources Subcommittee. So can I have a motion to do that?
I make a motion that we create a Human Resource Subcommittee to make the, what do I want to call them? What do I want to call the word that we're going to do for the director?
I'd say the hiring,
the hiring,
evaluation, and termination.
Thank you. And let me start all over. We'd like to make a motion to approve the policy and procedures for the executive director committee to go over those policies and procedures. Did I say that okay?
Yes. Is there a second?
I'll second.
All right, any discussion?
Mr. Nixdorf, hasn't that been done? I mean, haven't we done it? I thought you did that. I mean, I thought that's you presented that to us.
No, there was never accepted. There we do have a hiring policy, but my own thoughts are, if you're doing an HR subcommittee, you should probably evaluate that, as well as the evaluation of the HR executive director, and also the termination. You do have a hiring policy, but you don't have an evaluation policy, and you don't have a termination policy.
But isn't that something that you just need to do as part of your normal day-to-day?
No, that's typically done by the board, because I don't hire, evaluate, or fire myself. It's the board that does that.
But I mean, shouldn't you create the protocols for it?
I'll be working with the committee, certainly, but it really is board-driven.
Alex, I'd like to say, remember, part of the problem when we went to try to hire Gary is we didn't have a policy in play. So we need a policy of how are we going to review him. We need a policy of how are we going to work with going over what his goals are, and how are we going to terminate him or discipline the director should that come about. Because if you don't have the policy, remember, we couldn't do anything. Our hands were tied with a lot of stuff that we did. So that's the reason that we really need to do that, and it is our responsibility to do it.
And Mr. Leader, if you remember last meeting, we didn't come to a consensus on it, and it was a rather lengthy topic, and that's why we wanted to create a subcommittee so that we could discuss this at length. Okay. Any more discussion? All right, so then I'll call for a vote. All those in favor of establishing a Human Resources Subcommittee, say aye.
Aye.
Aye. Any opposed? All right, that passes. Motion carried. Okay, so now we have a subcommittee, and now I'd like to...
Perry, the most important question, now that we have the subcommittee, is there anybody that'd like to join us?
That's what I'm going to do here, all right? That's the next thing on the agenda, is to be able to staff that. I've volunteered to chair that. Koki's a member. Would anybody else like to be on that committee?
I'd like to volunteer to be on that committee as well.
Excellent. And I think that would be good. And I think, is there anybody else that...
I'll serve as an alternate. So if
No, you have to all be members or not. And I would suggest that you have odd numbers just because I had a situation recently with a subcommittee where they had even numbers and they had a tie and it was not very fun. So I would suggest odd numbers, and you have to either be on it or not be on it. So alternate doesn't work.
Commit, Alex. Commit.
And I would say that we should keep it low, like 3 here, because the more people, the more that we need a quorum, and so on and so forth. And I think that the 3 of us, a 3-person committee could easily knock this out in probably 1 meeting.
I agree, because these aren't really complicated things that we're doing. So I think we could, and then we've got to bring them back before the board. So
correct.
I think that it would be best with 3.
All righty.
I agree, and everyone will have their last and final say at the board meeting for final approval. So any revisions, modifications, or whatever that anyone feels uncomfortable with, you'd have a chance to discuss it at that time at the full board meeting.
Correct. All right. So, do I have to have any kind of action? Do we have to accept, or do we just say that?
No, you have to vote on create. You already created the committee, and you have to also determine in a public meeting who the members are, and that should be voted on. So you could have done that in one vote thing, but since we already created it, now it's just the people.
Okay. So I'll entertain a motion to.
I'll make a motion, Mr. President, that Mr. Nixdorf, Ms. Booth, and Mr. Hoffman serve on the Human Resources Subcommittee.
I'll second.
All right. Any further discussion? I'll take a vote. All those in favor, say aye. Aye.
Aye. Aye.
Any opposed? All right. Motion carries. Okay. Moving on. Number 21, comments by board members and future agenda items. Anybody have something to say on this topic?
I have a couple that I'd like to present for next time, and that is a procedure that maybe we can adopt or start, maybe be trendsetters in some way, where we require all applicants for business licenses that their records be pulled from wherever they're coming from, so we can make sure that we don't go through what we went through today. And printing the minutes, I really don't need printed minutes. I prefer them to come online if that's possible, otherwise only by request. And then lastly, speaking to director's report, to direct the executive director to apply the numbers for that strategic plan. So he can create the numbers and give himself some sort of stair-stepping goals, so we can, that'll equate to a raise. Is that what we talked about?
Yeah, we talked about...
We ran out of time, so I could...
Yeah, we were talking about statusizing the strategic plan or portions of the strategic plan to show progress or lack thereof. Anybody else?
I have one.
Koki?
I have one too, along the same lines that Jeanette did, is we've brought this up before. I'd like to see us, instead of having all this paper here, is to have a tablet here with our board our board package in that tablet. I'd like to have this downloaded. Maybe you're going to have to give us some papers for some of the different exhibits that need to be presented, but if we could just have that in a tablet. I don't want a computer. I'd like to have something that at least we could see the audience and they can see us. Our computer where you can take the top off and then have it downloaded, because it seems silly. We're FedExing it. Within a year's time, probably within 6 months, we could pay for those tablets. And I think that would really help, especially people coming out of town having to cart those back and forth. And it would save a tree.
Or 2.
And then my other would be, I'd like to have, I read your weekly updates, and you're going to be tearing down the one room in the back there to make it into a testing room. If we could have an update on that, and was it budgeted? Are we going to need more employees for that? And how is it going to, I'd just like to have an update on that portion of it. And then again today, I'm going to talk about something, being a real estate agent, I have to take so many educational classes every 2 years that I have to present. I actually have to do 33, turn in 33 credits. But I really see a need for when we're sitting up here, I would love to be able to say, you need to go take a class on sanitation. I don't know how we could do this, if we can work with the schools where we could actually send somebody and say, along with your fine, you're going to go take a sanitation class for at least 3 hours. So I don't know if there's any way to develop something like that. I'd like to have your feedback on that. So that's all I have.
Mr. President, I'd like to also add that I don't need the typed minutes any longer either. At one point, Mr. Landry provided me with the YouTube address, and I did. Wanted to review the minutes, you can go to the internet and just download the video. So if we could just be provided the internet address for if we so chose to watch the
one thing that we'll have to set up, just so you know, since Eric is sitting here and I want to make sure I'm fully compliant with the law, we'll have to set up a private address that you would have to get in with a password to get to get the minutes, because if the minutes are provided to the public, they have to be paid for at, Eric can probably tell me the dollars per page or whatever it is. We're not allowed to just give. Anyone can come in and take a look at the minutes in the board office, but we can't give away copies of the minutes.
And the video is not the official record. So the minutes that you're approving and that become the official record are the transcribed minutes that Mr. Nelson provides. So you'd still need to approve those. So I'm not sure the video could completely replace it, but certainly I think you could approve them in an electronic format if the board would prefer.
Yeah, and what we'll do is we'll convert the minutes into a PDF format so that you'll be able to take a look at them. But I'll have to work with Nadine on the website to make sure that it's secure, because only board members can have access to that.
And then I just also was hoping for a status update on the policy position of infection control and prevention for a subsequent meeting, I guess.
You had a subsequent meeting. Yeah.
Well, aren't we on future agenda items?
Yes. Yeah. So just an update on the infection control and prevention.
We all know that we approved the infection control and prevention terminology, right?
Yes.
Anyone else? All right, hearing none, I have none. Moving on to number 22, comments by general public. Is there anybody in the general public in Las Vegas that would like to come forward and speak on something?
Can I say something? It's really nice to have some general public out there.
Absolute troopers staying through the whole thing. Thank you.
And can I just make a quick comment for the board members? There was training last week for board and commission members. So if you'd like the handouts for that, please let Mr. Landry know and I can make sure you get them. We also are going to have, I believe, a DVD available of the training. But I would encourage you, if you're interested, to look at that. And if you have questions, to let us know. And perhaps we can have something on a future meeting for training, because I know sometimes it's been a while and you forget things or you want to refresh. So let us know.
All right.
Mr. Nixdorf, is there anybody in Carson City that had public comment?
There is no more public here.
So no then.
That would be correct. All right. Seeing that that's done, number 23, adjournment. It's now 4:20, and we're adjourning this meeting. Thank you very much.